And
Lisa, can you just identify for the record just who the regular voting members are who will be making the decision tonight?
yes, David Collins, myself, Jay Jackson, Wendy Taylor Humphrey, and who did I forget?
George. Okay. And Julie's an alternate?
Jennifer is the alternate, first alternate, and
okay.
Mr. Bishop is our second alternate.
And Julie Barrett's there. Okay, Julie. Julie's I'm sorry. Julie's our clerk. I'm sorry. I forgot about that. Yeah.
Right.
Okay. Thank you. All right.
Okay.
So, Madam Chairwoman, the first thing on the agenda is the
petition filed by Jeremy Kane for a variance.
Yep.
2029 Crandall Road, Tiverton, requesting a variance to the dimensional regulations table. Appendix A, Article 5, Section 1 of the Zoning Ordinance. This property is located in an R80 residential district, and the applicant is seeking to construct a garage addition to the existing single-family dwelling, and the proposed side yard setback of 29 feet does not meet the minimum setback requirement of 35 feet. Mr. Tights, are you here?
Yes, I am, Madam Chair.
Okay. Are you outside your office?
Just a virtual background. Where would you like me to be?
No. It's, okay. Would you? We heard this 2 months ago in part.
Yes.
The Canes were not represented, and they had requested a continuance in order to confer with legal counsel. So I assume you're their choice.
That is correct, Madam Chair.
Okay. I believe that all of our regular zoning members were present for that beginning of the testimony 2 months ago. Is that correct?
Yes.
Okay. Mr. Tights, why don't you go ahead and present your case?
Sure. Just for the record, Andrew Tights, T as in Thomas, EITZ, an attorney with offices at 2 William Street in Providence, Rhode Island, as you can see from the sign behind me. I'm here representing Jeremy Kane and his wife as they're seeking basically just one dimensional variance, a side yard variance. And they are seeking, in this zone, 35 feet is required. And they were seeking a 6-foot variance so that they would have 29 feet on the side yard. We discussed this and heard the concerns of the zoning board. They heard the concerns that you had at the last time. So we're actually reducing this variance by a third. Instead of seeking 6 feet of relief, we're only going to be seeking 4 feet. We've redesigned the garage. I'm sorry? We've redesigned the garage, as you'll hear in a moment. So instead of being 26 feet wide, it's going to be 24 feet wide. So the variance that we will now be seeking is 31 feet, where 35 feet would otherwise be required. Again, that's just out of 35 feet, all we're asking for is 4 feet of variance. I would just like to check, there were a couple of new exhibits that were introduced. These were actually sent before the last hearing, which kind of got aborted because of the lightning storm. But we had submitted, you should have a resume from Olivia Spence,
We have
our residential designer. And you should have a revised set of plans that were also submitted. And also you should have a resume from James Hool and Associates.
Yes, we have those.
Oh, okay. So I just want to make sure those were exhibits. And that, by the way, of introducing the witnesses, Olivia Spence will be talking first, then we'll have Mr. Hool. And I would just let you know that Mr. Todd Chaplin, the engineer, is available if there are any questions regarding the engineering stuff, as well as the applicants are available as well. So if there are no further questions of me, we'll move right on to Olivia Spence. I don't know if I think she is in, but she said she couldn't see herself.
I think I can,
Oh,
I can see
are.
myself now.
Okay.
And hopefully the
Sally,
board
would you
can as
swear the
well.
witness, please?
Sure, I'm just gonna change my gallery because I don't see her. All right, I think I have, let me see if I can do this. I just, let me see if I can do the gallery. I just don't see her, so I just want to make sure. All right, let's change this.
It's
Switch.
up here. You have
Okay,
both
please raise your right hand.
there.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Okay, Ms. Benson, I've got the same thing on the iPod. I can see myself or you, but not both of us at the same time on the gallery, so.
Okay.
Please bear with me if there's a delay. Anyway, I just want to confirm, so we have it submitted as an exhibit. I don't know what number, but it's your curriculum vitae. This is something you prepared, is that correct?
Yes.
Okay. And you have a Bachelor of Science in Architecture?
Yes.
Okay. And this resume shows your experience in design. You are a qualified residential designer, legally qualified to design single-family dwellings. Is that correct?
Yes.
And Madam Chair, I would ask that she be accepted as an expert witness as a residential designer.
Anyone have any problem with that on the board?
No.
Ms. Spence, have you testified before the Tiverton Zoning Board before?
I have not, no.
Okay. Have you testified in front of any boards or courts in the state?
Oh,
No,
right up
this is
here.
my first time.
I'm sorry, repeat that?
This is my first time.
Thank you.
Well, then,
I can go further through the qualifications if you
But I
want,
don't
or
even have this right now because they haven't let me in. Maybe that's why I can't see it.
Maybe I'll cut it.
I'll text Mike.
Hold on, Bill, we can hear you. Bill Moore, we can hear you. Hang on. Andrew, can you mute Bill Moore? Thanks.
no, Bill Moore is not, oh, wrong Andrew, sorry.
No, wrong, Andrew. Thank you. Go ahead. Go ahead, Lise.
I was just going to say Bill Moore is not my witness on this one. Okay, the other thing is, can I ask, so can we have Olivia share her screen with the revised set of plans that we submitted as an exhibit?
Yeah. I think Andrew, if you can permit that, thank you.
Sure, it's going to be the green button in the middle of your screen.
The screen share?
Yes.
Yeah.
Okay, great. So,
Okay.
so Olivia, if you could basically just walk us through showing what we're looking at here with the plans and what you've done with the garage as far as the dimension and the alternate that you had shown here, if you were to do a conforming garage.
Sure. So I'm not sure how, if you all are familiar with the last scheme that was presented a couple months ago by Jeremy, the homeowner. This first page here, EC.1, is just the existing conditions. You're seeing the first floor, the second floor, a rough section, and then the front elevation with the eastern elevation. So this first site plan is the original plan that was submitted a couple months ago, requesting the 24-foot deep by 26-foot wide garage, which would require a 6-foot variance, as we're roughly 29 feet from the property line. This is the resulting first floor plan, and the clients are requesting a 2-car garage, preferably with an entry door on this front elevation. And then we just see the resulting second floor and how this new kind of bonus space above the garage joins the rest of the house. Front elevation, side and rear. This second site plan that you're seeing is if we were to design the garage within the setback parameters. So in this scheme, we're proposing a 24-foot deep by a 19-foot wide. While this does remain inside the setback lines, we're only able to fit a single car garage, which is not what the homeowner is looking for. And also we would need to fit entry door on the northern face, which I've heard from the clients is more of a hassle than if the door were to be on this eastern face, just because of where the existing driveway is located. Again, second floor and how that lays out, front elevation, side and rear elevations. And then lastly, this is the new site plan that we're submitting and trying to gain variance for. Rather than being 24-foot deep and 26-foot wide, we're going 26-foot deep and 24-foot wide, which only requires a 4-foot variance. Rather than having two 9-foot garage doors and a single entry door, in order to reduce this by 2 feet, we've gotten rid of the two separate doors and just done one large door, and we're able to maintain the single entry door. And then resulting second floor space, front entry, side and rear elevations. And that's all.
And Ms. Spence, in your expert opinion as a residential designer, is this the smallest width garage which you can reasonably design to fit 2 cars into?
Yeah, I would say so. I think in order to get what they're looking for, we could not reduce this anymore, especially seeing this stair that's required to get into the main house, because it is up quite a few feet from the ground. There's no way that we could maintain a 2-car garage and reduce the width of this from 24 feet.
Thank you. I have no further questions of this witness.
I have a question. Miss Spence, why couldn't the garage go on the other side of the house? I mean, they seem to have the extra room on that side.
Does the engineer want to testify to this, or do you want me to answer this question?
Well, first, Ms. Spence, if you could answer it as far as from the architectural issues and the design thing, as far as what the layout of what you've got already on the second floor and the first floor, and how you're fitting it into it.
Sure.
And then we can let the engineer talk about it as well.
So if we go back to this first floor plan, and even looking at the site, I mean, the driveway already comes into this side of the house. So at a first glance, this side of the house makes the most sense in terms of impact to the site and creating a new driveway. But then when you look at the first floor,
Oh, hold on. She froze.
the current side entry door from the side door, if we go to the first page and we look at the existing floor plan of the house, if the garage were to exist on this side, you would be walking into either the living room or sitting area, I believe is there, and then a formal dining room. So the idea was to take the program that's already existing and the existing location of the driveway and modify it to fit a 2-car garage.
Thank you.
You're welcome.
Any member of the board have any questions of Ms. Spence?
Nailed it. Exactly right.
I think David has a question. David, you need to unmute yourself. There you go.
My question is, why do you need 2 cars?
Well, I think this is Andy Tights, and I think that's more the question for the owner and also our next witness, Mr. Hool. But in a nutshell, you know, given the suburban nature of this location, you're out there, you're about 100 yards away from Little Compton. There's no bus route here. You've got a 2-car family here. Someone's off going to work, taking the car. The other person, you got to go to anything with the kids, shopping, anything like this. You need 2 cars. A 2-car garage is a reasonable accessory use for a residential dwelling in 2020. And that's the reason for requesting that. There are other personal reasons as well. By trade, Mr. Kane's a mechanic. does work on cars, would like to be able to work inside the car, the garage as well. But beyond that, just from a legal point of view, I think a 2-car garage is the reasonable accessory use. I don't think you'll see many houses today being built. In fact, a lot of them are being built with 3-car garages.
I don't have a garage.
Some people don't have homes.
Do you want Mr. Kane to address that now, or how about if I have Mr. Hool go next?
Whatever you want.
Okay, then I would like to call James Hool as my next witness. Are you there? Do we have him? Olivia, can you stop sharing?
Yeah.
So we can get back to the
There we
view of
go.
everybody. All right, okay. Jim, we see you. Can you speak?
I hope so. I can see me.
Okay, you may need to turn your mic down a little bit. It's a little loud. Can we have this witness sworn in, please?
Please raise your right hand. I can't see you, but please raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And this is Andrew Tights again, and I'll just represent for the record that I did see him raising his right hand on my screen. Mr. Hool, you submitted a 2-page document with your entitled qualification of appraiser. Is that correct?
It is.
Okay. And that has also been accepted as an exhibit, and you've been accepted before zoning boards and planning boards and courts throughout Rhode Island. Is that correct?
That is correct.
And have you been accepted before the Tiverton zoning board?
I have. I think that last meeting was canceled, but the meeting before I had testified.
So I would ask that he be accepted as an expert real estate and appraisal.
Does anyone wish to, the board wish to question Mr. Hool about his qualifications?
No.
We'll accept as an expert.
Thank you.
Thank you.
So, Mr. Hool, are you familiar with the property which is the subject of tonight's hearing?
I am.
Yes. And could you just briefly, given the zone and the large square footage of this lot, but its shape, could you basically discuss that a little bit?
Well, let me just sort of go through the whole thing. I was contacted about this petition, and I went to the site. I had the petition, I reviewed the petition, I went to the site. I visited with the petitioners and took a tour all around the site and looked at where the garage was intended to be going. I looked at the neighbors to see what impact it was. I asked similar questions to what were asked here, why it wasn't on the other side. The distribution box for the septic system is on the other side alone, which makes it very difficult to do, but it would be in sort of the incorrect place in terms of the normal house configuration. Instead of being able to enter directly into sort of the back entryway, you'd have to go through the main house, which is not really the way the market expects this type of thing to be done. You have the distribution box on the other side. The logical place to put it is where it's being placed. It didn't seem like it was really impacting too much in the surrounding area. So I felt satisfied while I was on site that, in fact, that it actually would be a good idea to put the garage where they were requesting. I then looked through the rest of the neighborhood to find what other houses had garages, what other styles were around, what other properties were there, if there was any other possible impact. And when I got through with it, I really came to the conclusion that it was a petition that conformed to all the standards. Now, I came back, I looked at the particular standards, which I have gone through, and I'd like to just take a minute to do that, which is that special conditions exist which are special or peculiar to the land and not applicable to other lands and structure and not due to physical or economic disability. The circumstances surrounding the petition are definitely, in my opinion, not part of a physical or economic disability. They bought the house the way it is. It would have appeared, you know, quite frankly, it would have appeared that there was plenty of room to do it. They weren't exactly aware at the time when they bought it how far off of the sideline that the garage would have to be set. But it's definitely due to the way the house and the septic system were placed on the lot that created this situation that instead of being over a few feet, that would have facilitated putting the garage in, the house was put there by the builder before them, a little bit close on that side. So I felt that it really was something that existed prior to them being there. Such relief would not be, item 2, that such relief would not be contrary to the public interest or owing to special peculiar site. Literal enforcement would result in unnecessary hardship. I believe that's exactly what we're talking about here, that if we were forced to put this garage, it would not be exactly what not only the petitioners would like, but again, I constantly refer to this market acceptability. It's clear that when you go up and down the neighborhood, that every house that I found that did have a garage, and not every house had a garage, I might add, but I looked at the houses all around and they were all 2-car garages. This is sort of typical. This is what is expected for a house of this size, for a family to have. As Mr. Tights had said, it's very routine and typical for people to have 2 cars in a family. Quite frankly, a lot of people have more than that, but it certainly is. If you're going to have a garage, it should be, for this house, I believe it should be a 2-car garage. The other thing about the 2-car garage is it does allow, Mr. Tights also referred to the fact that Mr. Kane will work as a mechanic. This gives a lot more storage area in the back than it would be in a 1-car garage. It would be really tight. The 2-car garage allows, especially because they're making a little bit deeper now, it allows it to have additional storage area in the back, which I think is very important. And that fits in to the next thing, which is that there are no characteristics will be harmful to the neighbors. I don't see that there's any increase in lighting or noise. It's going to reduce noise. The only person that would even remotely be in a position to see the garage is the neighbor to their north at 2023 Crandall Road. But there's at least 65 feet of distance between that house and this house, or where the garage would be. In addition, there's a dense line of mature trees, so that except for maybe a couple of months in the winter, it's going to be blocked from view. The unnecessary hardship, which the applicant seeks to avoid, would not have been imposed by prior action. It was definitely not by prior action. It was not for monetary gain. They would simply like to have the convenience and the utility that a lot of other houses in the neighborhood have. The granting of the requested variance will not alter the general character. There's no way that this will alter the general character. When I referred earlier to other houses with 2-car garages, every house along the same side of the street is either a colonial or a ranch house, built about the same time, very standard style of homes. Number 2011, 2017, 2023, 2037 Crandall Road all have attached 2-car garages, and those are the houses right in the immediate area. So I don't believe that it would negatively impact the neighborhood. It would actually be very positive. And I think that the idea of taking the storage and being able to take, right now, when I was there, Mr. Kane had some items related to his work as a mechanic in the yard. These would be now hidden from view. I think it would actually be a benefit to the neighborhood to have it. Let's see, remove unnecessary hardship, the 6 foot, it's now 4 foot relief requested is certainly seen as the least relief necessary to enjoy a similar use that is common in the neighborhood. The no non-conforming use of neighborhood land, it's not non-conforming, it's simply that the way the position of the house is on site. And that I believe, honestly, this is more than a mere inconvenience if it was turned down for what is 4 feet, which still leaves 31 feet to the property line. And as I said, the neighboring house is actually set further back from the road and on an angle, and at least the full 35 feet from the property line. So we're talking over 65 feet that this house would be away. So I believe, having looked at all the criteria for dimensional variance and having looked at the side of the petition, I believe that it really is very much in conformance with the code.
I have a question. You indicated that there was a lot of vegetation between their house and a lot of trees between their house and the next house to the north.
Yes.
How would a fire truck get back there if in the event there was ever a fire?
The tree line is that there's enough space. There's actually enough room. The tree line is right on the property line. And when I refer to it as being dense, it doesn't come out, it's not particularly wide, it's just mature, and it created a full wall between that and the visual angle of the house to the north. In other words.
I'm sorry, can you repeat? I can't hear you. Can anyone hear him?
No, I
Not
can't.
really.
Mr.
Okay.
Hulu, sorry, we're having trouble with your microphone. We're not picking you up. No, try again. You're very staticky.
Right, maybe I'm going too close. Is that better?
Nope,
Nope.
Can you hear me now?
that's better, yeah.
Okay. So I'm
Oh,
No,
Lost you again.
no.
Nope.
that there is plenty of room between where the garage would be and the tree line. The tree line is mature, but it's not a very wide line, and I believe some of it is actually on the neighbor's property to the north.
Thank you. Anyone else have any questions? George?
I know this seems like not self-servicing, but I try to be as you keep mentioning that the fact you and Mr. Tight said the same thing, that it's possibility he wants to do he's a mechanic and he wants to do some work in this garage. I don't know if I live in that neighborhood and I have spent all that money on this houses around there, do I really want a garage? And I went to the site. I love what he's doing. It's not necessary. I'm uncomfortable about the fact that we think it's going to turn into where he do his mechanic work. Is that something on his cars, or all of a sudden we're going to
No.
have 17 cars in the yard?
No, not at all. This is Andy Tights, and no, this is the use he might make of the garage would be his hobby. He does. In fact, let me ask Mr. Kane to speak to that directly. That there's no way that this is becoming. I can understand that you don't want this to become a repair shop, and that is not
Because you
that
both
he's-
mentioned it, so I'm just going
Right.
about
No,
where
it's
we're
for
going with
his, it's the hobby aspect of it, not at all any kind of commercial thing. So can we bring Mr. Kane? I think he's already here.
Yeah, I'm here.
Okay.
Why don't you, Sally, can you administer the oath?
Please raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, so this is Andy Tights again. So, Mr. Kane, can you answer that question, Mr. Al-Zabak, who I'm sure he's not asking because he's worried about competition.
No,
But
Right.
if you could answer the question about your, tell him about what you do and why you wouldn't be using your home for it.
Right. So the hobby aspect of it, and in using the garage for the hobby aspect, as far as like the storage goes, is exactly that. So I know Jim Hool had stopped by the property, and I believe George, you did as well. And my hobby involves a lot of large parts, things like lifts and even spare motor parts that are too big, too heavy to move into a spot, say like the basement, which is obviously a hardship to get to, and then the shed all the way across the rear yard for storage. So a lot of that stuff sits just open in the driveway. So as far as when we say we'll use the garage for a hobby or for my mechanic work, the mechanic work, I have a full-time job. This is the work I do at home is strictly hobby work, and it would just be more of a convenience to have this stuff indoors versus letting it sit outside, being weathered, and then also to be honest, it's quite an eyesore. So it's as far as the hobby aspect of it goes, it's just a means of sheltering my equipment and my property correctly, and not having it outside in the weather.
thank you.
That helps you understand.
I'm all set.
Anyone else have any questions?
If I could, Madam Chair, I never got to ask my final question that I was going to ask Mr. Hool, if I may.
Oh, of course, go ahead.
Sure. So Mr. Hool, just want to give you the one big summation that in your expert opinion, for all the reasons that you set forth, if this application were to be denied, would it result in a hardship of more than a mere inconvenience to the applicant?
I believe very strongly it would, yes.
Thank you.
Why? Why do you believe that?
Well, because
You've got 6 acres of property. There wouldn't be another place to put a garage?
you could put a detached garage, you could detach further back, you could put even a larger garage and even closer to the property line if it was detached. But the thing is that it really is the most conforming use of the property to our garage attached on that northern side, which fits the configuration of the house and the room layout. And again, referred to earlier, fits them in terms of all the other houses that are right in the same area that have 2-car garages. They have identical placement. I think it might look, it's visually more conforming to have it where it is or where they are requesting. And really 35 feet from the property line, encroach 4 feet in, still leaves over 30 feet, which is a very generous, in my mind, a very generous space between the property line and the house.
Thank you. Madam Chair, I'd also like, I think I should address that question that you had there about the 6 acres, because there are, and it may not be visible on your site plan, or it might be in the application, there are wetlands immediately behind the septic system. And I would like to call Todd Chaplin, if I could, the engineer, to address that question.
Sure.
So are you there, Todd?
Yes, I am.
Okay. Could we have him, are you visible or just on phone?
I'm visible. I see myself.
Okay, and I see you too. So could we
All right.
have him
I
sworn
don't
in,
see
please?
him. I don't see him, but I'll take your word for it. All right. Please raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Could you just identify yourself for the record, please? Your name and
Todd Chaplin, President, Mount Hope Engineering. I'm a PE in Rhode Island and Massachusetts for over 30 years, and I've testified before this board numerous times over the years.
okay, thank you. And you're familiar with this property, which is the subject of tonight's application, yes?
Yes, I am.
Okay, and this is a 6-acre lot, but immediately behind this house, there are some wetlands. Could you tell the board about that?
As shown on our site plan, the actual wetlands are about 110 feet or so off the back of the house. The 50-foot perimeter wetland falls about halfway between there, about 60 feet off. The septic system is directly behind the house and about 30 or 35 feet from that perimeter wetland. So to try to relocate that septic system, besides being a fairly significant expense, would start to encroach on that wetland in the back. And then while the property itself is very large, that wetland is fairly extensive and runs out through the west for the vast majority of the site.
And I just want to clarify for the record, you're referring to, so with the application, there was submitted a document, Mount Hope Engineering site plan, and it was 3 sheets. Sheet 1 of 2, 3, 2 of 3, and 3 of 3.
Yes.
Okay. And on sheet 1 of 3, and I don't know if the board has these with them or not, particularly since the meeting wasn't there, and I don't think, unfortunately, we have it as a shareable item. But the locus map shows that this, although 6 acres, this lot is a very long, narrow lot, its entire way, and it jogs out all the way out to Stone Church Road. Is that correct?
Yes, it is.
And the width of the wetlands that run right behind the house off of Crandall Road, they run the entire width of the lot. Is that correct?
Yes, they do. They run from a north to south direction, but they do go across the entire back of the lot.
Okay, so then one would need a wetlands crossing from DEM and have to build a bridge if you were going to reach your garage from Crandall Road farther back on this lot. Is that correct?
Yes.
Or if you reached your garage from Stone Church and hiked across, you would still need a pedestrian crossing of the wetland. Is that correct?
There is a very a narrow access out to Stone Church Road, and there are some uplands on the far westerly side of that lot. I'd be just venturing a guess, but it's thousands of feet to the west of the house.
Okay. All right. I have nothing further of Mr. Chaplin, and I don't know if the board has other questions.
I just want to say to Andrew Tights that we do have the plan.
Good, okay. So then you can see clearly on S1 or sheet 1 of 3, the locus map shows the shape of the whole lot, as well as the other 2 pages show it.
Yeah, we have.
Okay.
I have a question.
I think I have nothing further.
I have a question.
Go ahead, Dave.
I'm struggling with the idea of the fact that 2 cars are required in this garage. I mean, certainly a 1-car garage would fit without any problems. And I'd like to hear some more discussion on why not being able to have 2 would be a hardship beyond a mere inconvenience.
Well, then why don't we ask Mr. Houle to come back and talk a little bit more about what's customary and normal as an accessory use for a single-family house. And as I said, I think you also have to look at the area. There's a difference between if you're right in someplace like, the village area of town, if there's public transport available, and there's another thing when you're out in a rural area here. But Mr. Hool's the expert. I'm not, we're not in this role anyway. So Mr. Hool, can you respond to this question?
Well, I think that you have to look at it as really as a total package. I've referred to the fact that they're asking, first of all, I believe honestly that a two-car garage is very important. I think that from an architectural, from a visual standpoint, a one-car garage doesn't really, quite honestly, cut it. It looks kind of like it's out of 1945 rather than a newer house that's been built in the last 20 years in an area where a lot of houses have been built in that period of time. From a real estate standpoint, just when you look at appraisals, a lot of it has to do with the curb, so that right off the bat, that particular
Hey, Mr. Hool, this is Mr. Hool, this is the solicitor. I'm sorry, you're really, I don't know if anyone else is having trouble, but you're really breaking up with your microphone, and I think we're having difficulty hearing you.
Okay.
That's much
Let me
better.
try.
No,
Is that better?
No, it goes in and out.
Maybe you can call in from your cell phone.
Sure. What's the number?
Andrew, maybe you can.
Does anybody have the number?
Yep, it's 1-888.
Hold on. Yeah.
788.
Yeah.
0099. I'll give you the passcode. If you could just mute your mic so we don't get the feedback from your computer, but I know you gotta get my number first. The passcode is, the meeting ID is 828-739-77320. And I don't know if you're ready. The passcode is 642277. We'll let you in. Hold on. Andrew, is he in?
No, I need to.
No, Andrew Rice, I'm sorry. What?
I don't think, I think he needs a number again.
Oh, sorry, you need the number again? It's, can you hear me, Mr. Hool? Yep. It's 888. No, I can't hear you. You need to unmute yourself. You need to unmute yourself, sir. Go ahead.
I have the number.
We're sending you the, if you look at the chat, we're sending you on the chat. Do you see that, sir?
Does not exist. Please re-enter your meeting ID followed by pound.
Hang on.
Yep. We just sent you the meeting ID.
Oh my God.
Can you, I'm gonna try this again. Can you, is it?
It's better right there. I don't know what you're doing, but it's very good right there, yeah.
So what I was saying was that simply from the standpoint of the visual, that it is, I believe, better to have a two-car garage than a single-car garage. Aspect of it on the lot, that logical place to have an attached two-car garage because the other side does not work. If you look at the dimensional set, still 31 feet from the side, and that is a fairly generous setback considering how is not only setback, but even further back, set not in line with the house, but it's set further back from the house. So when you look at all, and they did not build they bought the house the way it was. It's already been described that the lot is a little bit longer and narrower, so that when you put all the factors together, you're only encroaching, and they made attempts constantly bring this back so that it would be smaller. And I really believe that at this point, it is the minimum relief necessary. The code has provisions for it, allows variances. These are, in my mind, the exact situation that the code exists to give this opportunity for a variance. So I believe that, sorry, George. And I believe that that's why I say it's a minimum variance. George?
So I have a question. I keep hearing that it's an Aurora area and not necessarily how I'm staying with my boat, but I'm just saying, I live just up the street from them. I have a garage. It's not a 2-car garage. It's garage like a car and a half. You could just only park 1 car, but you got plenty of room for storage on the side of it. Not necessarily 2 full-car garage. It seemed like there's a way to build something without asking us as a board to give you a relief where there's a chance you could put a car and a half. It's a 1 big door. You could easily put 1 car. You could store a lot next to it. This is how I live, literally up the street from them. Can you just address that, why that is not a possibility?
It's a possibility. You know, Olivia Spence has already demonstrated to you that it would indeed fit, that she could design a garage that would fit on the lot. But this, I really just believe that the visual of having a larger garage is what people really expect to see today. And when I look at the neighbors that immediately surround it, when I see their garage situation, it's all 2-car garages. It's either no garage or a 2-car garage. I don't know how long ago your house was originally built, but you know, that may have had something to do with it. That back then that would have looked like a generous garage when the house was constructed. Today, Mr. Tights referred to the fact that a lot of people are trying to put 3-car garages on their houses. This is certainly not any kind of an attempt like that.
Yeah, no, but I understand. But people who already either don't have a garage or they're trying to build a 3-garage, they're not coming to ask for a relief. This is just, we're trying to see, I'm trying to understand what is a minimum we could do and still give them some of what they want.
I think I can help answer that question too, maybe a little better than Jim.
Go ahead.
So if I may, so I know it's come up. Why not have a 1-car or
just
George?
identify yourself for the record first.
Oh,
Speaking.
oh, I'm sorry. This is Jeremy Kane, the homeowner.
Okay, great. Thank you.
So it's come up. Why not having a 1-car versus a 2-car? Obviously, the 19 feet would allow for a 1-car, a large 1-car. And the main reason for that is that's not how I, as the homeowner, identify the needs of my family, of myself, and of the property. So I know going up the street, some homes have no garages. Maybe it's because they don't have garage, they can't afford garages, or they don't have the intent to build one, and they don't need one. Before applying for this variance, myself and my wife, we strongly considered a 19-foot garage without applying for a variance. And we, for weeks and even months, considered its viability and working for our family. And a large part of this attached garage, I think, which is maybe overlooked, is the bonus space up top. And in that case, it's kind of like a dual purpose here. So we've been talking about the purpose of the garage and the storage for the garage. And I know like 2 cars has come up a lot, and I'll talk about that. But the other aspect of it is the living space up top. When we purchased this house in 2013, we were maybe, we were misled into what we could do with the property to the north. we were shown a plan when we bought the property in 2013 that showed a setback that was incorrect, or maybe it's changed since then, but it showed 30 feet. So when we purchased the house, we anticipated building a 24-foot garage because we're actually shown a site survey with a plot plan or a plan for a house with a 24-foot garage. So taking that, we grew our family off the idea that in the future we would have the space to build a 24-foot attached structure, not necessarily a garage, but a 24-foot attached structure, in order to gain more living space for our growing family on the second floor. And then, of course, the other half of that is the garage on the first floor. So, like I said, it's come up, why not having a 1-car versus a 2-car garage? And to answer that, not only does that not meet our needs because we are a 2-car family, and then on top of the fact that we are a 2-car family, I have this equipment and stuff in the yard that it's an eyesore and I need to get out of the weather, and that would be the easiest solution to get rid of that stuff. But on top of that, it's also the living space, and the living space that a 19-foot structure would give us, with the pitched roof and the space in the walls there that's not livable. It's really not even enough for a large bedroom. So I guess that's what it comes back to. If that helps answer your question more about why having a
well
1-car.
said. Well said. I appreciate it. I got the answer.
May I say one other thing too? I don't know if you can hear me, but
Just identify yourself for the record.
I'm sorry, this is Jim Hool again. But the only aspect of relief that they're requesting, Mr. Tights brought this up, but I'd like to really emphasize it, is that one sideline dimensional setback.
We lost you again.
What I was saying was that Mr. Tights had referred to this, but I think it bears repeating, that the building will fit all height. There's no need for dimensional front or rear. The only aspect of relief they're requesting is this 4 feet on a sideline that I just don't believe will impact anything. So I think that it's important to note that when you talk about the least relief necessary and a mere inconvenience, it is only that 4 feet on that one side, that it has there's no other dimensional, there's no problem with lot coverage, there's nothing else. That's the only one item that they're requesting.
Thank you, Mr. Hool. Are there more questions from the board, or?
I have a question for you, and that is the way our ordinance is written, we are required to find that that if relief isn't granted, that the hardship is going to be more than a mere inconvenience, and that there is no other reasonable alternative to enjoy a legally permitted beneficial use of one's property. And I'm struggling with that.
Okay, well, first of all, as I think you know, the second part of that phrase, there's no other legally permitted use of the property, that has been struck down by the Rhode Island Supreme Court several years ago.
Oh, no, well,
Although the Tiverton
it was in
zoning
the ordinance that I was reading, so.
Right, but it was struck down by the court. So the state law is in fact just the more than a mere inconvenience, which is in fact what it always used to be under the old VD variance standard as well. So that would be the first thing. And I think, you know, you've heard the testimony from Mr. Hool and Ms. Spence, and also from Mr. Chaplin about the unusual shape of the lot and everything. I think you've heard it all, that this certainly would be more than a mere inconvenience. What would the contortions that would have to be done here, or to have a one-car garage. I also want to just follow up and guess, you know, what Mr. Hool was just saying. This is not, we're not like in an area where there's a 10-foot setback, a side yard, and we're asking for 4 feet out of 10 feet. We're asking for 4 feet of relief out of a 35-foot wide side yard, which is really big. we're asking for 11% relief, or 11.4% to be precise. That's all we're asking for. That's a rather minuscule relief. The neighbor that's most affected on that side is not in any way complaining about it, and there is a large mature vegetated buffer between them. So it really seems to be a de minimis type thing compared with, I know the hardship, it's, you know, I think it's certainly more than a mere inconvenience. I think it would be, as you've heard, it's going to be, it's going to result, there are several alternatives, all of which are much more than just a mere inconvenience, you know, from the major one of having to put a wetlands crossing in if you were going to have it in the backyard there, to the lesser hardships, but still the problems with the not being able to fit the two cars and not being able to have the room up above, or having the substantial expense of having to relocate a driveway and the septic system features on the other side, and also then having your garage door enter right into your living room. So I think there's a lot there in the way of inconvenience, much more than a mere inconvenience, much more than a scintilla of evidence to that part. And then on the other side, you've got 11% is all we're asking for. We have reduced the size of it, and that's all we're asking for now.
All right, anything else you want to put on the record?
No, I don't think so.
Okay,
Thank you for your time.
sure. We'll now go begin our deliberations. How does the board feel about the application? Who'd like to start?
Madam Chair, first of all, you need to ask if there's people in the audience. who
Oh,
would
yeah,
like to
thank you.
speak.
Since I can't see anybody, I just, is there anybody in the audience that wants to be heard? Okay,
Hold on, Lisa, we gotta do this correct.
how do we do this?
So if there's anyone in the audience would like to speak, you need to raise your hand and in Zoom, or if you're on the phone without Zoom, *9. Give us a second. Last call, anybody who would like to speak for or against this application, if you're in Zoom, please use the raise hand option, or if you're on the phone, please press *9. Doesn't appear to be anyone, Madam Chair.
Okay. Who'd like to start discussion? George?
Hey, so I went and visited their property, and it's always struggle when you see what's available or what could be done there for the size of the property. But after you see the paper and the application was put forward, and the way the house is set back, even when they put this garage, actually it doesn't even, you can probably see half of it from the street. You buy a house, you think about what you, as the owner says, how you're gonna expand your life, your kid, your family. I'm really not having a problem with the two-car garage. I appreciate the fact you pointed the living space upstairs, which is, for me, it's more important than the actual garage. I know we're always trying to be careful what we're gonna give, and if they meet the hardship and all that, and we have to make the legal language work. If I've said this before, if it was just about what reading on the paper, they don't need us. They could put somebody in the room and apply what's in the paper and say, this is what the law said, have a nice day. I think we have to take into consideration sometimes the situation and the people we're dealing with. I don't have any problem with it whatsoever, none, zero.
Okay. Dave? Since you're next to me in the box, how do you feel?
I'm still struggling with this one. I'm not sure how I want to go on it. As George says, it probably has zero impact on anybody.
Yeah.
However, not being able to have two cars, is that really a hardship beyond a mere inconvenience? I'm not sure. So I'd like to listen to some of the other people before I make a final decision.
I have the same concerns that you have, and I certainly would want to help somebody that needed it, but, I'm looking at the fact that I've lived in my house for 30 years without a garage, and, it's an inconvenience to me that I don't have one, but it's still, I'm not convinced that criteria has been satisfied. I mean, I'm sure it's preferable. It would look nice. It would, be an addition to his house. But I'm very ambivalent about this. And so I need to be convinced that this is okay. So who's going to do that for me?
Me.
Yeah, I already heard from you.
Okay, well, there's somebody else that
Jay, help me here.
Hey, listen, we're looking at 4 feet. I guess that's what I'm looking at. It's 4-foot variance. On a lot that you guys have said so big. And like George pointed out, you can't use 3/4 of it. There are a 2-car garage at this day and age in 2020. If I was going to build a garage, I'd want a 2-car garage. I just don't. I'm certainly in favor of it because, let's look at a car. A car. What's the expense of a new car today? 40 grand. I'd want that covered up. If I got 2 of them, that's 80 grand. I'd want that covered up. Never mind his tools and his equipment that he's trying to put in there. Then he talked about his family. His family needs a little more room. Another bedroom. That's like George is pointing out, that's probably more important to house his family properly than it is to put 1 car in the garage. So, you're leaving me. Trying to talk to you. You got a wife like that.
A burglar alarm just went off.
Welcome to Zoom meeting.
Sorry about that.
No problem. You got my feelings. I'm in
Yeah,
favor
no,
of
it's
this.
good. Wendy?
I think I'm in the same position that you and David are in. Jay made some good points. George made some good points. This entire hour plus that we've been going back and forth on this, I've been going back and forth. There are things that make me agree with it and things that make me disagree with it. And I'm in the same position of you as you. I feel that I need a little bit more convincing, and I'm happy to have that convincing. I get a little concerned when they start talking about the bonus space. Just the word bonus doesn't sound like a hardship. It sounds like icing on a cake. And at the same time, I agree with Jay that even though my own car is parked outside, I see why people want to be able to park every car that they have inside of a building. I wish they would have gotten a little bit more specific on how they were duped when they bought the property, because that's very interesting. If that was by the town or that was by a realtor, I think that information would have come into play a little bit in my decision making, but I'm still a little bit on the fence. So maybe Jen has something to contribute.
I don't think she can deliberate.
Yeah, I can.
Oh, they can deliberate. They just can't vote.
Oh,
Yeah,
okay. Go ahead.
Mhm.
I always
Let's hear
do.
from Jen.
She's been waiting.
I was trying to look up this property on MLS from when they bought it to see if there was a survey attached, but there is not. However, I think from a real estate perspective, I think having a 1-car garage is very unappeasing. I think it'll make the structure look odd on the lot. So I see both sides. I'm having a hard time as well. However, I think I'm more leaning towards Jay and George's side of it because of that aesthetic. And I think they would have a harder time selling it in the future with just a 1-car garage. And there doesn't seem like there's a better spot on the lot to put it between the septic system location, the G box, and just the the layout of the home, it doesn't seem like there's an alternative place for it. So I appreciate all of that. I think the actual living space, it sounds like they're expanding their family and they need more space with storage and, you know, living space. I think they should have dwelled on that a little bit further, because I feel like that would have been a better hardship, but not my application. So I think aesthetically, and I think from a saleable point of view, I think the 2-car garage does make sense. I think at the end of the day, they're asking for 4 feet. So if I was a voting member, I think I would be for this petition.
Thank you.
I think
Anybody
Joel
else?
had his hand up before.
Sorry?
Joel,
Joel had his hand up.
Oh, I don't see him on my thing.
I don't
Oh, yeah,
blame
here
you.
you go. Joel, do you want to have anything you want to add?
Yeah, absolutely. Can you hear me okay?
Yeah.
So I'm Joel Bishop. I'm not a voting member, but I do believe that they have shown a hardship. They've outgrown their space, and it's an undue hardship to try to move the garage. This is the place. This is the driveway. They shouldn't have to move the driveway. Moving it to the other side of the house is definitely going to be difficult. As usual, this comes to a property rights issue. You know, they want to be able to put it in a garage. I don't have a garage on my house, but I would love one. And everybody has 2 cars today. I mean, I have 3 at least. I might even have 4. I don't know. I have to go count them. I have a lot of cars, and they're all outside, and I don't particularly like it, but I don't have the money for a garage either. The additional hardship of not having any space in the house, they've outgrown their house. It's you know, there's things outside, as they mentioned, that don't look nice having things out in the yard. So the garage is also going to make the place look nicer. But I say, all of that aside, this comes down to property rights. There's a 35-foot setback. This is 11%, 11.4% variance. And if the neighbor has no objection to it, I say this is between the homeowner and the neighbor. If both of them agree, then we should definitely, absolutely grant the variance.
Well, are we prepared to, anyone prepared to make a,
I just,
Madam Chair, this is Andy Tights. I know you're deliberating.
yeah, we are.
But if one of your members expressed a desire to see a certain exhibit, what we didn't include as an exhibit, I don't know that it has legal probative value, which is why it wasn't, but it was requested. The site plan that showed the wrong distance on it. We can, if you want to reopen the hearing, Ms. Spence has it and can share it. We can show it to you if you want.
I think it's,
Just make that offer.
I don't know. I'd like to ask our legal counsel if we can reopen this while we're deliberating.
Sure. I mean, if you feel like you'll get new information that might help you make a decision, absolutely.
Okay, that's fine. As long as we can do it. I've never done it before.
Well, I think the key is before you close and whatnot,
Before you make a
and
decision.
after we speak, that you give just ask again if for anyone in the public to raise their hand in case we've said anything that would get them. But so then I guess at this time I would ask Andrew, if you could allow Ms. Spence to share her screen again, and Ms. Spence, if you could, you told me you have that plan. So
Yeah,
if you
let's see.
you could share it.
Okay. So this is the document that I got from the homeowner. It's basically showing here, if I could zoom in, that where the house was supposed to allow for a 20-foot wide garage and a 30-foot minimum setback. So based on this site plan, the house was situated quite a ways over from where it actually got built.
As well as the fact that the side yard is incorrectly shown on this plan as only 30 feet minimum required as opposed to 35 feet minimum required.
Oh,
yeah.
If you can just circle that where it says 30-foot minimum there.
Yeah, we see it.
Yeah.
Okay.
And Ms. Spence, where did you get this? What is this document? Was this what the plan was when the Kanes purchased the house?
Yeah, I believe I got this document from the homeowner in the beginning stages.
Madam Chair, do you want me to have Mr. Kane just answer that question?
Yes.
Okay. So Jeremy, could you just answer where you got this plan and when?
Yep, this is Jeremy Kane, the homeowner. So this document I received as part of the closing paperwork when we purchased the house in 2013. But when we viewed the house, one of the first things I had asked was if we would have room for a garage, and this document was presented to me fairly quickly as evidence, so to speak, that it was already approved by the town. And that we wouldn't have a problem, and this and that. And that's kind of the extent of the conversation we had, because at that point, to me, maybe in my naivety, I thought everything was good to go. And so that's when I speak of having this planned out for the past 7 years. This is the document I'm referring to, and this is the document that was that was shown to me by the realtor, but also was included, I believe, in the closing packet. I saw this, I don't know if it was part of the packet, but this I also saw at the lawyer's office when we closed on the property. So it wasn't just a document that was handed to us and then kind of like tucked away. It was a document that throughout the entire closing process was kind of viewed and looked at.
I don't understand why it says proposed 4-bedroom dwelling. Wasn't it already built when you closed?
Yeah, this was just.
Yeah. I think what you're looking at, this was the plan that was submitted to DEM for the septic system.
The original septic design?
Yes, that's what it appears to be. This was a DEM
I
septic
have a
system plan.
question. On the original building permit for this structure, I don't know if you guys know this or if Bill knows this, did it call for a garage?
I don't know the answer to that.
It's just funny that they have this all engineered and done. I don't know whose stamp is on this because I can't see the whole paper, but it's just odd that they have the garage already there. It would make sense if there was a garage on the original building permit and then they just never did it.
That's and this is Jeremy Kane again. And that's what the realtor said was it was already all the work was done, and there was I was actually, the way it was explained to me, and I can't remember the terminology, but I was under the impression that under the gravel in the driveway there was a concrete slab. So I don't know if that helps convey like how it was worded to me, but in my mind it was like all set, everything was approved for the garage, it just wasn't built, but it's ready to go. And maybe that's unhelpful as far as helping you understand how the document was presented, but it was presented in that manner, that it was supposed to be a 26 by 40 with a 24-foot attached garage. So
I can see that.
Yeah, but that's the document. So I know it had come up while you were deliberating was one of you would like to see that document. So that is actually the document.
Question on that document?
I'm sorry, David, I didn't hear you.
Question on the document.
Yep.
That document shows a future dwelling to the north. And I assume it's been built.
Yes, I believe it has. I was just on Map Geo.
Was it built where it's shown on that drawing?
No, but
and that house appears to be at least 60 feet from the sideline. And the testimony we've heard is that it's more like 35.
No, I'm looking at it on Main Street maps, and I just did a measurement, and it looks like from the side of the house to the property line, and obviously this isn't super accurate, but it says it's 62 feet.
But can I ask a question? When you're doing closing and you want to hand it all these documents, these homeowners did not read where the house built and the setback and everything. They were handed the papers, tons of papers, and this is what was in there. We're trying to question something the day of closing. I guarantee you, they're not even aware of what that paper measured or is said. So we need to deal with what we have in front of us today, an hour and 20 minutes into it. That they're not gonna know the answer to what that paper came into the closing, a stack of papers.
Bill? Go ahead,
So, my name is Bill Moore. I'm the building official. That document is the septic plan that's in the file in the building department. The problem is it's all proposed locations. All these septic designs were done proposed locations. So the owners have, you know, a little bit of leeway to move the buildings around sometimes when they build these homes, but it's definitely on the plan. It was a modular home. They have a CO. The CO was issued in, well, that can't be it. 2002? Is this whole house that old?
Yes.
Like 2002. No plans of a garage except on the septic plan. That's it. You know, there's no as-built in here showing the actual location of the foundation on the property lines. We usually require it, but I don't see it in the file.
Thank you.
Can I get back to that? Mr. Hool, I thought you said that that house next door was about 35 feet away. And it sounds like we're hearing maybe 60 feet or more.
Can you hear me? Is it?
Yes, I can hear you.
What I tried to say was it would have been at least 35 feet away because I couldn't get on his site to measure it, nor, you know, did I know exactly where the boundary line was. I mean, I have a very good idea where it is. If you were on site, you could see there's a change of elevation at the property line. You know, I'm not allowed to go on his property to measure it. And the point that I was only making was it's a minimum of 35 feet away from the house. If you looked at that diagram, what I thought was very interesting is you could see that the setting for that house was much further back from the road, which is also what I testified to. So it's not only the distance from the sideline, it's actually the distance from the house is really significant. It really, the side of his house that faces this garage is really a distance from the property, both in terms of the angle, but also the distance. I just couldn't be accurate because I couldn't get on the site.
Thank you.
Oh,
Anything else before we continue deliberating?
Nothing on our end, Madam Chair. Thank you very much.
Okay.
I guess your solicitor's probably going to want to have you give people a chance to raise their hand in case anybody wants to speak again after us, just to keep things.
That was a
clear.
good point. Thank you. So if anybody on the Zoom wants to comment or on this application, given the extra testimony that was just heard, please indicate by using the raise hand feature on Zoom, or if you're on the line, please dial *9. *9. Doesn't appear to be anyone, Madam Chair.
Okay. Well, let's continue discussing this.
I think just for fairness, I mean, if you still want to deliberate, it would be great to get a motion so you can have you know, a motion so you can really discuss after the motion. I do want to remind the board, and I'm not trying to sway you, this is a 4-foot side yard dimensional variance that we're seeking. And it's whether he was building a garage or a porch or a deck, it's really irrelevant. It's the side back you got to worry about. It's not, you put any structure there. So I just want to let you clarify that.
I'd like to make a motion. I'm not good at making these, but I'd like to make a motion to grant the petitioner's request. I'm not good at it, but we should move on. I can't word it. All I could say would make a petition to.
So the motion would be that the motion to approve the dimensional variance.
That's it. Thank you.
Yeah,
Ready?
I'll second that. I'm gonna second that motion.
Okay,
I'll
Jay.
look at my paper to, first of all, that there's the septic issue on the back side of the house that limits where they can move this garage. There's also the wetlands where they couldn't put it in the backyard behind the septic. They bought the house as is, so they did not have an opportunity. They didn't produce this hardship by moving the house one side or the other as when it was built. They built it as is, as we see it. And again, we're talking about a 4-foot variance that they have reduced from the last time they were here. They were asking for a 6-foot variance. They've taken the time to get someone else to look at the property, give them a little bit more expert advice, and reduce that down by a third. I think that's a pretty tremendous amount of work, far more than most applicants we see in here. You know, they're family. They're in town. That's all.
Can I add one thing? Am I allowed? My feeling, if you went down to that property, as I wish we all do sometime, it literally sometimes we prove stuff that it really eyesore and we don't have a choice. This garage really will fit, it will look good on that house, and you really cannot see it. And his next door neighbor, who we are concerned about 100%, is not here, not complaining, and you really will not see it from the road. It will not jump at you. They and I had finally, as I said earlier, I finally got him to say what most important to me is that living space upstairs. You buy a house, you expect to expand yourself in your life without have to sell the house and move somewhere else. They're not asking for anything extraordinary. They're asking for a 2-car garage at 4 feet different. We've proved the stuff a lot worse than that, and it looks uglier than that. So I appreciate if sometime visiting those sites, you could have got sometime an emotional feeling about it, which is we're not supposed to. Again, I disagree with that motion, but that's garage will not jump on you the first thing you look at the house. That's not the first thing you're gonna see. Will be part of this house. So I think this family need to expand. I was asking for a little 2-car garage. Doesn't matter if we have garages or not, or we have 3 cars or 4 cars. I have 11 registered cars and I only have 1 car garage. So that doesn't count what they're dealing with. It's good to have, it fits at the house, fits in the neighborhood. It's a rural area. No one's gonna bitch about it.
Okay, so shall we vote?
Yeah,
We ready to vote?
I am.
I am.
All those in favor?
No, Madam Chair, you have to do a roll call.
A roll call.
Yeah.
What do you mean I have to do a roll call?
You got to call each member, and under the modified rules of the Open Meeting Act, because of Zoom, each member has to vote.
Oh, okay.
How about I do it? Want me to do it? Want me to call the roll?
No, I'll call the roll.
Okay.
George?
I'm all for it.
Okay, Jay?
Approve.
Okay, Dave?
I'll go along with it. Yes.
Okay. Wendy? Can't hear you.
Can't hear you, Manny.
Approve. Approve.
Me? Approved. Congratulations.
Good luck.
Good luck.
Thank you very much.
Thank you very much.
Yeah.
Yes.
Okay. I have to find my agenda. Here it is.
Boy, I don't think this was the hard one tonight.
We have Endeavor Holdings next.
All right, the next matter is a special use permit. A petition has been filed by Endeavor Holdings LLC, 67 William S. Canning Boulevard, Tiverton, Rhode Island, requesting a special use permit for a new sign. This property is located in the Highway Commercial Zoning District and currently has 2 exterior signs. Applicant proposes to add a third exterior sign, which is prohibited pursuant to Article 12, Section 4B, permitted number of the zoning ordinance. Applicant is seeking a special use permit subject to Article 12, Section 11, special use permit of the ordinance. Is there someone here on behalf of the petitioner?
Yes, hello?
Hello?
Yes, hi. This is, yes, can you hear me?
Yes.
Okay. Yeah, just to answer your call about who's here, I know Tommy Nasser's here as the facilities manager. He's the primary. I'm here as a consultant. My name is Tom Castleman.
You, I'm sorry, either speak up louder and slower. I did not hear.
All right. Yes, my name is Tom Castleman. I'm here along with Tommy Nasser, who is the facilities manager for Aspire Dermatology. I'm the designer and builder of their corporate signage.
Who, I had some questions about this. Who signed the application?
Yeah, Tom Castleman, I did.
Okay.
And Tommy Nasser is the primary. He's the legal speaker for the corporation. I'm as a consultant.
Well, has there been any authorization by the business authorizing you to represent them?
I don't represent him. I'm here only as a consultant. Tommy Nasser is the sole representative of the corporation.
Okay.
I am here.
I'm confused by this because it indicated in the paperwork we had that a contractor signed the petition, and I wasn't
Yeah,
sure.
I signed it. Yeah.
Who said that? I signed it. Who said that?
Yeah, this is Tom Castleman.
You signed it.
I signed the initial application for the building department.
And your title again, Mr. Castleman?
I'm a designer builder.
And Mr. Nasser, what is your position?
I'm the facilities manager for Aspire Dermatology.
And does the business, did the business who's in charge have it sign an authorization for you to advance their position today?
I was told that since I'm representing a company that I'm the one that is authorized to represent the company.
Okay. And who told you that?
I believe that was at town hall.
Okay. Okay. I had some problems making any sense out of this petition. So, there were no indications of where the signs were located or what you wanted to do or what the proposed sign was going to do. So why don't you try to explain to us what it is you're asking us to do?
Okay. So did you get does everybody have our package that was sent over?
Yeah, we have it, but it was kind of hard to follow because it had built the design of the building, but no pictures of the sign other than the one that was on the top.
So I apologize for the miscommunication there, but on our north side of the building, how can I say this? We put up a new addition just recently on the building, 36 by 30 addition. So the north side of the building is rather large, and it does have enough room for us to put a sign on the building. The reason why we're asking for it, or I guess if you want, by listening to the last one, the hardship that you're looking for, or we're looking for, is we have a lot of elderly patients / clients that visit us, and a lot of them come off of Route 24. When they come off of Route 24 now, if you can picture over at William S. Canning Boulevard, it's a very, very busy area. When our clients come off that north side and travel south towards us, a lot of times they're missing us, especially the elderly clients, and they're going by our building because they can't see our road sign until they get over the top of the crest of the road. Then they end up in the rotary at the casino, and they honestly, at times, they feel lost. So they have to find themselves around the casino, and by the time that they get into our office, they're flustered. And mostly the elderly customers, the elderly clients. We do have a road sign that's out there, but the problem is when you come up from the north going south and you get up to the top of the crest with all of the traffic and everything else that's going on in that congested road, you lose sight of it, you can't see it, and by the time you know it, you're already past the entrance to the building. So if we're allowed to put the sign up on the north side of the building, it's much, much higher than the road sign. So they would have more visibility to be able to see and get into our property maybe a little bit easier than what they're doing right now.
Did I miss it? Did you indicate any design for the sign that you want to add or where you want to put it?
When we submitted the application, they asked for that. We did. We put that there is a picture of it on there.
I
On
have a
page
picture.
14 of the application, Lisi.
I'm sorry?
On page 14 of the application, it has the design and the north wall of the property. It shows the windows and the.
Page 8 here. I mean, we have a picture of it, Lisa, in the application.
I'm sorry, I'm on page, what is it?
14.
Mine is 6 of 8.
Yeah, I see that, but I didn't see where they want to put it.
That's exactly what it looks like, the building, the new building.
Building on the side. It's like right above the windows. There's 3 double hung windows and 2 transom windows. It's above that, like towards the peak.
That's correct.
I see that. Is that the sign already there?
No.
It's not there yet, ma'am. That's what we're asking.
Okay, because I couldn't figure out where you wanted to put it or what you wanted to add.
That sign that you're seeing in that picture is is our request to put that sign on the side of our building to make it easier.
Okay.
For visibility purposes, please.
Jen or George, can you hold that up to the screen?
Yes.
I can screen share if you guys want.
That would be awesome.
Hold on.
Right there.
That's correct.
How's that?
That's perfect. For some reason, mine's not opening at the moment.
Hey, Jen, do you have the page, the grainy page? It said SP Technology Tiverton.
Yes.
Okay, do you guys have this one? Lisi?
Yes, I do, and I just didn't
So
understand. We have an existing sign, then we have a replacement sign?
This is the existing sign where they're showing you, and they just add in the other one to the building.
That's all.
Existing.
Yeah.
New.
That's the addition and where they want to put the sign, down where the arrow is right now.
And you already have a sign on the front of the building, right?
There's no sign on the front of the building. There is a sign on the south side of the building, which serves the same purpose, so that when they come off the rotary, they can see us.
I've driven by this so many times.
I know. It used to be a farm stand.
I go
from
there
what
all the time. I
understand.
never noticed that. I thought there was a sign on the front of the building. But maybe I'm
Yeah,
full of it.
there is a road sign that's up front, but it's quite small and it gets missed quite often.
Okay.
Well, that intersection is getting so ridiculous between the marijuana, the gas station, and everything else. Yeah.
There's a lot of traffic that comes up that road, and you know the main thing is we're concerned about our elderly patients that are trying to get into our property and
Yeah, I understand.
they just can't see.
So you currently have 2 signs and you want a third, is that correct?
We have, yes, sir. We have the road sign that we do have, and we have the sign that is on the south side of the building. But obviously, that sign doesn't do any good to our clients that are coming in from the north side.
So would you explain to us why you can't eliminate one of the 2 that are already there?
Well, the road sign is the road sign. If you pass either one of the other signs, you won't see it. And the south side serves the same purpose of what we're trying to do on the north side. The visibility factor with that area, when on the south side, if you come around the rotary and you start traveling, if you don't look quick on the left, you don't see us, you're gone.
Bill?
Yeah, sorry to interrupt. I just want to give you a little clarification. Joe Kaufman, he's the zoning enforcement officer. He usually handles all the signs for us. He's here, but I just wanted to explain, they have by right 2 signs. To add a 3rd sign, they need this special permit. It's not a variance, it's a special permit. You just ask for permission, as long as it's not detrimental to the neighborhood and it gets the job done, it usually should be something that seems reasonable. That's why they're here. I just wanted to explain that to the board so everybody understands it's not a variance, it's just a special use permit. We've given them out many times before. It's much better when people ask for permission than when we have to
Ask
go
for
and
forgiveness.
enforce signs that are put up illegally. So I'm really happy that they came and asked for this sign.
Thank you, Mr. Moore.
That's all I'd like to say. Thank you.
Okay, thank you. Is there anything else you'd like to add?
No, ma'am, we just appreciate your time.
No problem. Is there anybody out there in Radio Land that would like to ask any questions?
Hold on, can we get rid of the screen share for a second, please? Because I can't see. Thanks.
Sorry.
That's all right. All right, if there's anybody on Zoom who'd like to comment on this application for a special use permit, please raise their hand in Zoom or dial *9. Madam Chairwoman, does not appear to be anyone who would like to comment on this application.
Okay, if there's nothing else you want to add, why don't we go into deliberations on this petition?
I'll start if you don't mind again.
Take it away.
All right, so I drive that road probably about 6 times a day. I absolutely understand their dilemma. First of all, as you come off the highway, you're dealing with the traffic, especially on Friday, Saturday, Sunday of the marijuana place and the cops and the traffic. And if you're an elderly person coming off that road, then you get the gas station with their own traffic. You literally lose that building and easily. And I'm not, I don't like a lot of signs and whatnot, but that area kind of exception between the building behind them with all the stores and all the traffic that's to the right of that building, same direction where they're going into their parking lot, you could easily miss their building. I actually thought it was a great idea to have that sign where they want to put it. It's not like they're going to be a neon sign or anything. It's going to be just a simple sign. Actually, it's a wonderful idea. I'm totally for it. I don't think any issue with it whatsoever.
Anybody else want to share their thought?
I'll say that I have no problem with this. I think they meet all the requirements for a special use permit.
I do too. Anybody have a problem with this?
No.
No, I think they easily meet the requirements, especially where they're located.
All right, David, go
All
make a
right.
motion.
Make a motion?
David, make a motion.
Oh, okay. I make a motion that we grant the request for a special use permit. Number one, they have shown that the public convenience and welfare will be served, particularly when it comes to the elderly. It will certainly not be detrimental to the public health, safety, morals, or welfare of the area. And I think it will be compatible with neighboring uses. I don't think it's going to create a nuisance in the area in any way or hinder or endanger vehicle or pedestrian movement. As far as water, sanitary, sewage, all that doesn't really apply. I don't see that it's not compatible with the comprehensive community plan. So that's the motion.
I'll second.
Okay, and all those in favor, or let me ask you, and I have to
Roll call.
poll you. George?
Yes.
Yes. Jay?
Approve.
Wendy?
Yes.
Dave?
Yes.
Lisi? Yes. Congratulations. You're a
Thank
big
you so
winner.
much, everyone.
You're welcome.
Thank you.
We really appreciate it. We try to make our place look really nice over there.
I'm sorry that I couldn't figure out where the sign was going.
That's okay.
It looks
That's
good.
okay.
It looks like it belongs.
It
You,
belongs.
I promise
Nice
you,
job.
you're gonna love it. It'll look very nice.
I'm gonna love it. Thank you.
Thank
Have a
you.
good night.
All right, bye-bye.
Bye.
Bye.
We had that was on our agenda, inland fuels, but the petitions being continued December 2nd.
Madam Chair, Madam Chair, can we just vote on that? I'd like to have a vote on that. So the board knows we got because of some additional information from the fire department or fire marshal's office, the applicant contacted my office. They needed some more time to address the concerns of the fire department. And therefore, with the chair and the clerk's assistance, we told them that we would take a formal motion to continue this to I think it's our December meeting. We just need a formal motion so we don't have to re-advertise.
I will make a motion that the board allow continuation.
I second a motion. I'll second it.
Okay. Yeah. A roll call. Wendy.
Yes.
You agree to continuance?
Yes, ma'am.
Dave?
Yes.
Jay?
Yes.
George?
Yes.
Lisi? Yeah. That matter is continued to second.
I'd like to ask the question though, when, back a few months when they originally came to us, Inland Fuel, the fire chief or whoever it was gave us that letter the day of the meeting. Now, I want to know how a application gets through planning, then gets to us, and then, the fire department shows up at the last meeting. And I guess my problem is, this is the second time this guy's done this. And it kind of pisses me off that people go through all the time and expense and engineering. And then this guy walks in and goes, hey, wait a minute, I'm the fire department.
This is Julie. Can I just say something?
No, can I just interrupt for a second?
Oh, sure, sorry.
These are all good discussions that we should have at the time of the hearing. We shouldn't really be discussing this now. We just continue the matter, so the matter's continued, and we just need to discuss it at that point. And Jay, if you have any questions of the department, outside of the meeting, you can certainly call Julie, but we really should be discussing it now because we just continued everything.
Hey, can we ask Sally to mute her microphone because her typing is all, we could hear it.
Sure.
That wasn't me. That was someone else.
Somebody else is
I was
typing?
hearing it too.
That's Bill Moore. He's typing. He's working away.
I was hearing it too. I might be Julie.
Well, whoever is typing, mute your microphone.
Because I don't have a normal typewriter keyboard. This is a stenography keyboard. It has no sound.
Okay, sorry,
It's
Sally.
not Julie either. Sorry.
Oh,
You're
okay.
right, Sally, you're not normal.
Nope,
Okay.
I'm not.
Okay, let's move on. Last matter on our agenda is an appeal, a petition that's been filed by Highland Ridge Pharmacy, 139 Willow Avenue, Little Comfort Island, appealing the cease and desist notice from the building zoning official at 536 Highland Road rear. The property is located in an R40 residential zoning district, and residential dwellings and farming are the only principal uses permitted by right, together with accessory uses. The building's official asserts that the applicant is preparing to develop a 40-foot wide strip of land, which requires prior approval from the Department of Public Works. Applicant is also appealing the determination by the building official that the 1974 gravel permit is invalid. And is there someone representing the petitioner? Hi, Beth.
Hi, Lisa. How you doing? Elizabeth
Good.
Noonan on behalf of Highland Ridge, and my client, the principal, Tom Chase, should also be on the line if someone can admit him into the call.
I'm sorry, what was your last name, please?
Noonan, Noonan, Elizabeth Noonan, Adler Pollock and Chan, 1 Citizens Plaza, Providence, Rhode Island.
Thank you.
Lee, how do you want to proceed? Do you want me to just start with my position?
Okay, I'm here.
Okay, I guess we're all here.
Good.
I believe Bill Moore's here, and I think Bill Moore's represented by counsel as well. Bill?
Yes, I am. Justin Shea should be on the line. Could you please let him in?
Justin.
Hey, Justin.
Good evening,
Okay.
everyone.
Hello.
So Beth, I guess, Chairwoman, it's Beth's appeal, so she
So
might
she
want to
goes
go.
first.
She goes first. Yeah.
Yep.
No problem at all. Again, thank you very much, Madam Chair, members of the board. On behalf of Highland Ridge, we're here on an appeal of a cease and desist that was received on July 23rd, 2020 for the property map 310, card 112. The property is currently zoned R40. It's about 90 acres of property. There were two sections to that violation, if everyone has it in front of them, hopefully, as we go through this. We filed the appeal and listed our grounds for appeal, then you should have that document. And then today, actually yesterday, I received a letter from Mr. Moore. Not sure what it is, if it's just expanding his position or what. I thought there was a rule. I caught your discussion before. Everything had to be introduced 10 days in advance. As you know, this hearing had been continued from last month due to the power outage. So I would actually make a motion that to strike that it should not be allowed in. And as it is, it wasn't complete when I received it, and I didn't get a complete copy of it until late this afternoon. Let me go through and finish the rest I have to say. This is an appeal a little different than what you normally do. I don't know how many appeals you've had. The standard of review is different than the review for either for the special use permits or the variances that you see on a normal basis. And specifically section 23-81A of your ordinance provides a standard of review that you shall not substitute the administrative officer's determinations, findings, except and unless there is prejudicial procedural error, clear error, or lack of support by weight of the evidence. And we have state that we believe that all three of those exist in this case right now. What I'd like to do is start with the second violation first, if you might. And what I'm going to be referencing and going through is the 7/23/2020 violation. And in that, Mr. Moore stated item number 2, that Mr. Chase has presented a gravel removal permit to show that he has vested rights to quarry gravel mineral property in perpetuity. He had then made a determination that the permit was void. As a matter of law, and this is fairly clear under Rhode Island law, that this zoning board and Mr. Moore do not have the right to make the determination of what is an existing lawful existing non-conforming use. I set forth those cases in our appeal, but I think it's Rico Corporation versus the town of Exeter, that is in the Superior Court's jurisdiction. So as a matter of law, I would ask that be denied by this board, or that our appeal be upheld. In the event that the board does not agree to take that position this evening, I submitted last month some additional materials from Betty Jerome regarding the property and some of the history on the property. She will be available by phone to attest to those documents that they were hers. We'll get her on the phone at some point to attest to those documents. So that's as to the grandfathered rights, as they're so called. Again, we believe it's firmly within the jurisdiction of the Superior Court. And so it should not have been a violation in the first instance via Mr. Moore and through this board and that procedure. So that's on the non-conforming use aspect. The second has to do with now the first issue in that notice, and let's go through it while we're here. So what Mr. Moore wrote, starting, Dear Highland Ridge Farm LLC, he describes the property, but then at the very beginning, he says, I'm writing you this letter due to activity on the subject property, which will need further approvals from the town of Tiverton before you start development. He then goes on in numbered paragraph 1, you and/or your agents have been preparing to develop a 40-foot wide strip of land which intersects Old Main Road from the subject property. The problem with this statement is that he doesn't even say what is happening on the property and what the violation is. He mentions some issues with grade, that we need to get a curb cut. Those are all premature, or actually, I guess, his coming in is premature at this point, and he doesn't even describe what activities towards development. He cites and includes the definition of development from your code, which is any alteration of land. So theoretically, anything you do to your land is development. That doesn't make it a violation of any laws. What we did state, and Mr. Chase can state, but I stated it in my appeal, he was removing trees from the property. That was it. That's never mentioned by Mr. Moore that he was removing trees. And so this lacks specificity. There's no evidence to back up what was doing. There's no pictures as to what was happening. Absolutely nothing in the record. We're the ones that have come forward and told you, yes, we are cutting trees. And we don't need permission to cut trees on our property. This is a 90-acre parcel. Absent wetlands regulations, a homeowner or an owner of property rather is free to cut down trees. Mr. Moore did not cite him for any town violation in relating specifically to what he was doing. Didn't say that he was in wetlands, didn't call DEM, nothing like that. So it's our position that this notice that he gave is also, it's vague under the standards. It doesn't apprise him of what the actual violation is or the extent of it, and is simply not actionable in any way because it doesn't even clearly state what the potential violation is. If you go then further into that letter, again, he talks about other dwellings and that you need to protect neighboring properties, but again, with no citation as to what he's talking about. So it's our position as a matter of law that he has failed to cite any evidence as to what's actually being alleged to be in violation of the law of the town of Tiverton. Now, he does this letter that I got fully today for the first time. He expands a little bit on this. And I would ask again that this be stricken from the record. What we're dealing with are the violations that he found at the time of July 23rd. I don't know if what he submitted is a new violation. It talks about additional issues, additional concerns that only muddy up the waters and are completely unfair. Talk about procedural error. I get it this afternoon. It's dated October 30th, and I got an incomplete copy yesterday, which may have been just a clerical error, and I'm fine. I understand that. But this board has a rule that everything has to get there 10 days in advance. I didn't get that information. I get it right before this hearing. And I don't know if he's trying to augment his findings from before, which again puts me in a very unfair position if he's throwing stuff in now. This has been out here for a while. This was continued last month. He had more than enough time to do any of that. But if you look at this letter, and again, I am making a formal motion that it be stricken from the record, is that he then goes in and starts to describe, let me just find it, hold on, I'm looking for it, 1 second. This is a letter that's dated October 30th, 2020, and then it states that it was reissued as of today. And in there, again, he goes through and he starts to expand a little bit more. And I just think it's fundamentally unfair if he's dragging in new factual issues at this point. What I would like to do now, unless there's any questions right now, would be to ask Mr. Chase just to testify a little bit as to what exactly he was doing on the property at the time of the violation. Although Mr. Moore hasn't said it, but we're not afraid to tell you what we were doing because we would believe it was entirely lawful. There's been absolutely no indication that it violates any laws. So with that being said, unless there's any questions, I would like to ask Mr. Chase a few questions.
Sure. Sally, if you could swear in Mr. Chase.
Tom, raise your right hand, please.
You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, can you state your name, please?
Tom Chase.
All right. And Tom, what is your relationship to the party that has appealed here, Highland Ridge?
I'm the owner.
And were you aware that Mr. Moore had been out to the property in July of this year inspecting the property?
Yes.
All right. And were you there? Did you speak with him when you were there?
I didn't speak to him when he came over with to stop the tree cutting. No.
Okay. Can you describe what you were doing in relation to the tree cutting? And this is in July of 2020.
We were cutting trees just about to one of the neighbors' houses.
Okay. And were there, how long have you been in the development business, Mr. Chase?
Since 1994.
And are you familiar with the Department of Environmental Management regulations regarding freshwater wetlands generally?
Generally, yes.
And where you were cutting trees, were there any, to your knowledge, any wetlands in that area?
There are no wetlands in that area.
Beyond the tree cutting, what other activities were occurring in the area that Mr. Moore was looking at in July of 2020?
I don't know what else Mr. Moore was looking at. That's all we were cutting trees.
All right. And you're familiar with the cease and desist order that was issued, correct?
Yes, I am.
Okay. And in that cease and desist, Mr. Moore makes mention of the fact that you were developing a roadway. You recall that?
Yes, yes.
Okay. In fact, the actual quotes from his July 23rd cease and desist was, "You and/or your agents have been preparing to develop a 40-foot wide strip of land which intersects Old Main Road from the subject property." Mr. Chase, was that what you were doing in July of 2020?
I was cutting trees.
All right. Okay. All right. I have no further questions for Mr. Chase on this. I would ask if the board could determine whether or not it's going to accept the October 30th reissued November 4th letter. And if they are, whether or not it's going to be accepted.
Well, I'd like to ask the witness some questions before we get to that.
Certainly.
Mr. Chase, why were you clearing those trees?
I have a farm there, and I was clearing trees, cutting for cordwood.
And is it just a coincidence that it's you were cutting trees in an area where you're seeking to get approval from the planning board for development?
Right now, I'm not seeking to get a development from the planning board.
Okay, and how were you removing these trees? Were you just using a chainsaw?
Chainsaw and a skidder.
What's
I hired someone to cut it for me. I don't generally handle chainsaws.
Okay, and was there any blasting involved?
No.
Stump removal?
Any what?
Stump removal?
Dump removal? No.
Stump.
No.
Stump. I think.
Stump. Oh,
I know,
stump.
I heard dump too. Stump.
Oh, okay. So you said stump removal? No, there were no stump removals going on.
Okay, and were you hauling wood out of there?
Wood was being hauled out, yes.
Okay. Are you familiar with the definition for development in Article 2, paragraph 26 of our zoning ordinance?
No, I'm not.
Well, it includes in a definition of development as any land disturbance or alteration or extension of use of land.
Okay.
And
So I'm a farmer and I'm running my farm.
And are you familiar with the provisions of the town code, section 65-3?
No, I'm not.
Well, it has some provision for disturbance to terrain, topsoil and vegetative ground cover on any property in town. It's unlawful to disturb vegetation that may increase the potential for soil erosion.
If I might, Madam Chair, those none, I don't believe we were cited under that section.
Well, I think it's a consequence of what he was doing, and our law requires that that it be, there has to be an application to the zoning official in order to determine whether there's going to be soil erosion by the removal of vegetation. So I think it's relevant.
But this is an appeal of a cease and desist order. It can only be what was cited in the cease and desist order, not anything else that's being raised post that violation. That's it.
But we're supposed to just ignore the consequences of another. I mean, really, this is
Of what? Of someone cutting trees on their own property?
Well,
And
if it's because of the unique location of the land, if it's going to contribute to soil erosion and interfere with the neighbors' enjoyment of their property in terms of water, flooding, or anything else along that, I think that the zoning official is within his obligations.
Well, he's the building official, not the zoning official, as far as I understand it. So
He's both.
I thought he said someone else was a zoning official earlier
He's
today.
the
so-
zoning enforcement officer.
Okay.
He handles complaints.
Okay.
May I speak, Madam Chair?
Not yet, not yet.
Not yet. I was asking for, it was a question that was pending to the witness, which of course I can't remember at this point.
You were asking about section, I believe 65-3, which was not one of the areas I believe that Mr. Moore cited for violation. So I don't think it's appropriate at this time. If he can answer the question, fine.
I have a question.
Yes.
It's very, I'm going to repeat some of the questions she asked, but I'm going to ask them to. So you were cutting the wood for, because what, you need a core wood, you said? That's why you're cutting the trees? So where did
I have a lot of trees. I have a lot of trees on, it's 90 acres of land. I have a lot of trees on the property.
I'm going after the question the way you answered it. You said to her, I've needed some quarter wood, so I was cutting the trees. That's what you said.
I was cutting trees for cordwood, yes.
Okay, so where did that trees went? Where did they go to be quartered? Like who's cutting them for you?
Jim Royce from Tiverton is cutting them for me.
And they're going for personal use?
Not for my personal use, no.
So how many trees did we cut down?
Well, I have about 70 acres of trees on the property. No, I take that back. Let me see.
I think his question was how many you cut down. Is that correct?
How many trees did you cut down? One,
How many
two,
did you
seven,
cut down
15?
in July of this time frame? Yeah.
How many? Maybe 100?
100 trees.
Yes.
Well, we could warm up the whole town of Tiverton for that. Okay, thank you.
You're welcome. Thank you.
Anyone else have any questions?
Justin?
Can I, one quick question for Mr. Shea, I mean, sorry, for Mr. Chase. You said that you were a farmer. Can you explain a little more what you farm and what your farming designation is on that property?
I am a farmer in the state of Rhode Island. I grow hay, typically. I took over the operations when Mr. and Mrs. Jerome sold the property to me. Ed had beef cattle on the property. I don't have any desire to raise animals. So I am growing hay on the area where the NRCS has designated it as hay fields.
Can you tell them what the NRCS is?
That is a conservation, it's a National Conservation Service. And they have an easement on 16.5 acres of my property, which Ed and Betty Jerome sold to them. And that is 16.5 acres of that are fields. And the restrictions on the fields are you can graze animals and you can grow hay. And that's pretty much it. I also have a field up top that's accessed by a right-of-way, which is in dispute right now, off of Budway. And that field is very difficult to get to from the lower parts of the property. So that is, well, that is going to be my vegetable gardening field. And then that is being expanded. And that is one of the reasons why I've been cutting trees.
Mr. Chase, Mr. Moore's letters or cease and desist also addressed issues of, as we talked about, I talked about before, about earth removal and non-conforming rights. I don't think there's any secret that there's granite on that property, correct?
There is granite on the property, yes.
Okay. And under the earth removal statutes, if you're familiar with those, is granite included under the earth removal statutes?
No, it is not. It's specifically exempted, actually.
Okay. All right. And when you received the notice that said, it said, you know, preparing to develop, did you understand specifically what Mr. Moore was referring to?
I'm not sure. Mr. Moore thinks I want to put in a roadway.
At this time right now, or at the time of July of the violation, were you putting in or taking steps to put in the roadway?
No.
And you are aware that ultimately, if you put in the roadway, you will need a curb cut or possibly other approval from the planning board, correct?
Correct.
All right.
Yeah.
And
if I want to go further, I'll ask for the permits.
Right. And have you in the past submitted a curb cut application?
Yes. Yes, I have.
All right. And has that been acted upon by the town of Tiverton?
I'm not really sure if they've acted on it. I know they haven't approved it. I'm not sure if they actually denied it. I think DPW has just sort of ignored it. I'm not sure. I'm not really sure.
Right. So from what you're saying, you are certainly aware that if you wanted to make this a roadway, you need the curb cut approval from the town, correct?
Correct.
And you know at this point that you don't have it in hand.
Correct.
Okay. Nothing further right now for Mr. Chase.
Anyone, member of the board have any questions of Mr. Chase? Any member of the public have any questions of Mr. Chase?
Madam Chair, Justin Shea, may I inquire briefly?
Sure.
Mr. Chase? Madam Chair, members of the board, my name is Justin Shea. I'm an attorney with the law firm of Cameron and Middleman with offices at 301 Promenade Street in Providence. I am here before the board representing Mr. Moore in this proceeding. Before I have a few brief questions with respect to the road. As Attorney Noonan pointed out, we have a second issue here with respect to removal of gravel and potential non-conforming use. Will that be taken up separately? If that's the case, I will limit my questions now to just the few I have with respect to the road and then take up the gravel removal later in the hearing. Is that how we're going to proceed?
Madam Chair,
Who are you asking, directing your question to?
Oh,
To
I'm
you.
sorry, Madam Chair, to you, of course.
Well, whatever you please. I mean, you'll have questions of them one way or another. So however you want to proceed.
Well, I actually, like I said, it's a matter of law, and I would think that Mr. Chase's opinion right now, because this board does not have jurisdiction to get into those questions right now. I don't think this board should be doing that. And I don't think Mr. Chase is necessarily prepared to answer all of those questions, because I've told him that as a legal matter, this board does not have jurisdiction, so that testimony should not be relevant.
I actually like to ask our attorney what he thinks. I will respect to your opinion.
Sure, of course.
Thank you.
I want to, Justin, why don't we just focus on the road cutting, the tree cutting for that now. We'll go back to because Beth didn't even address that yet. And I want to address the letter as well, your supplemental letter. Go ahead.
Okay, thank you. Mr. Chase, you have access to this almost 90-acre parcel, is that correct?
Correct, yes.
And how many different means of access are there?
I believe there are 6.
And where do those, each of those 6 means of access originate from?
Okay, let's see. Highland Road, Old Main Road, Old Bolgamarsh Road, Bud Way, 2 locations, and Daniel Page in the new subdivision over there, William Barton Preserve.
Oh, thank you. Now, you have filed an application with the Tiverton Department of Public Works previously for a curb cut.
Yes.
And where was that point of access that you were applying for?
Old Bolgamarsh Road.
Old Borgomarsh Road. And would that be access to get to the area of the 90-acre parcel that you were clearing last July?
Yes.
Is that application presently pending before the Tiverton Department of Public Works?
I'm unsure on that.
I'm sorry?
I'm unsure.
You're
I do not know.
You don't know if it was denied or dismissed or what have you?
It's been at the DPW for about 3.5 to 4 years.
Okay, it has not been acted upon.
Well, it was originally, it was for a subdivision prior to me being a farmer. Now, I spoke to Mr. Rogers, Richard Rogers, and explained to him that if anything, I would like a driveway coming in from Old Bolgamarsh Road.
Okay. Do you know what the width of the driveway that you're planning to put in is?
The width of the driveway?
Yes.
16 feet, maybe?
16 feet?
I'm not sure. I haven't looked at the, I haven't looked at that in quite some time.
Okay, does that mean that the pending application for the curb cut would be rendered moot by this new desire to put in a driveway?
I don't know if Mr. Chase can answer that question, and I think we're getting a little far afield from the July cease and desist order.
Easy, that's up to you to make a decision.
I beg your pardon?
I'm just waiting for the chair to make a decision on that objection.
I think you should answer it.
Good. Mr. Chase, can you answer the question?
Oh, okay. Could you ask the question again, please?
Does the present intention to possibly place in a driveway moot your prior application for the curb cut and the road that would be running from that?
I don't know if that makes it moot. I would like a driveway there, yes.
Okay. So are you telling us that you have no intention of putting a road in for development?
Whoa, timeframe. At the time of the violation, yes.
Or presently?
That would be you mean today or July?
July.
No.
I'm sorry?
Could you please ask the question again, please?
Yes. At the time of the violation in July of 2020, was your desire to install a driveway of 16 foot in width, a substitute for your prior application for a curb cut to put in a road for development?
In July, I want a driveway in there.
In July, I wanted a driveway.
It wouldn't take the place of it. I would not just void out the application for the curb cut.
Okay. I have no further questions, but I would like to return possibly, depending on what develops with respect to the removal of gravel issue.
Can we ask questions or no?
Yes.
So I'm a little confused about a couple of his questions and answers. He's the way he answered them. So in July, when the violation occurred, so you were trying to put a driveway or you just cutting woods for trees for wood?
I was cutting trees for wood.
I know, but you just said in July I was doing it for a driveway.
No, I was cutting trees. And I have an application into DPW for a driveway from Old Bogamarsh Road.
In July?
It's been there for 3.5 years.
I don't want to
It's
argue.
been there
but
for a long, long time.
He just asked you what you were doing in July during the violation, and your answer to him was, I would put in a driveway. This is, unless I am
No.
Okay.
I did not say I was putting in the driveway. I said I was cutting trees, which is exactly what I was doing.
I know, I figured 2 months to get some wood. I could,
Actually, I mean, to be fair, Mr. Shea's question was, in July, did he essentially, I think he was asking, did he want the driveway or the original curb cut application that he had applied? Those are pending things. It's not necessarily that that's what he was doing at the time. That's been there for a long time, and so has the driveway. So I don't think he's admitted and told under testimony that he knows that if it's going to be a driveway, he needs a curb cut. But that doesn't mean that application that's been pending there for 3 years means he can't touch his land for 3 years, as far as I know. I don't see any regulation prohibiting that, even if this driveway may not come into fruition for 6 months, a year, or another 3 years. It doesn't limit his use of his land.
I'm just looking for a straight answer.
I know, it was kind of, I'm trying to clarify that.
Could I ask Mr. Chase a question on behalf of the board, Madam Chair?
I'm sorry?
Could I ask Mr. Chase a question on behalf of the board?
Yes, of course.
Mr. Chase, when you got the letter of July 23rd, 2020 from Mr. Moore, where it asked you to cease and desist development activities, did you have a conversation with Mr. Moore after you received the letter?
Yes, I did.
And what was the nature of those conversations? What did Mr. Moore indicate to you that he did not want you to do on that property? If anything, what did he tell you?
I believe he didn't want me to do anything on my property.
Okay. Did he mention anything specific?
No, I don't, not that I recall, no.
So at the time that you received the letter, you had already cut trees?
Yes.
Okay. And in the same area that you're cutting trees is where you intend, or at least as you testified today, you would like to put a driveway, at least a driveway, into the that allows access to the 90 acres of the property?
Yes, I would like access onto my property.
All right.
And at that point.
At that point, for a driveway?
For a driveway.
All right.
Yeah.
And
that's why the application is on at DPW.
Right. Okay. Well, the application is for a driveway or for the 40-foot access to the property. That's what I'm a little confused at. I think the board may be a little confused.
Well,
So
the driveway goes in from Old Boca Marsh Road on
Okay.
my 40-foot strip of land.
Okay, so the driveway will be on the 40-foot strip, okay.
Yes, yes.
So the area where you were cutting the trees is the area where that driveway is, correct? Well, let me rephrase that. The area, the driveway where the area where you were cutting trees is within the parameters of the 40-foot strip where you want to put the driveway. I'm not saying the driveway is going to be 40 foot, but it's in the same area. Is that a fair statement?
No, when he gave us a cease and desist, we weren't at the 40-foot strip of land.
Okay. But you were in the area.
In the area, yes.
Okay, all right. But you weren't in that 40-foot strip?
No, no.
How close to the 40-foot strip were you?
Probably 100 feet away. The 40-foot strip is 185 feet long. Something like that, maybe 200. No, I'm sorry. The 40-foot strip is 212 feet long, if I recall. And from there onto the bulk of my property, we're probably about 100 feet away from the 40-foot strip.
Can you tell the board when did you begin cutting trees on that property in this area?
April, May.
Of this year, 2020?
Yes. Yep. We cut some last year also.
Okay.
Maybe half an acre.
Thank you.
Ew.
Beth, I don't know if you have any follow-up.
Yeah, just Tom, last thing. In addition to the trees that you just described for the solicitor that you had cut down last year, April and May, have you, at the time that you've owned this property, cut trees in other areas?
Yes.
Right. And have you ever been violated or issued violations by the town of Tiverton for cutting trees on other portions of your property?
No.
I'm all set. Thank you.
Okay.
Thank you.
Justin?
No further questions on the road issue right now.
All right. Thank you. All right.
But Mr. Moore, I think, is looking to be recognized.
Well, I want to give Beth an opportunity. I don't know if she's done.
Okay.
The only thing is I did want, and this goes on to the non-conforming issue, is Betty Jerome would be there. We're going to call her just to verify some documents that we've submitted to previously, if that's obviously I assume they're in part of the record, but I wanted to have her just address those. So I don't know, Tom, maybe if you can just reach out to her and see if she can call in at some point and we'll get her.
Beth, can I just clarify that the purpose of Mr. Roan's testimony is to bolster the fact that there was activity on the property related to quarrying or prior 1973?
Well, my first argument obviously is that this legally should not even be considered because of the jurisdictional issue that I've raised. However, if the board is not deciding that way, I have submitted some documents from Ms. Jerome that I would just like to have her, whatever substantiates. She can't come, she obviously can't just to say these are mine under oath, that sort of thing. So, so it depends on how things go.
Yeah, I'm okay. It's up to the chair. I'm okay. I've seen the affidavit. I'm okay with that. To be honest with you, the issue of whether or not the board can even hear that is something they're going to need a little bit of research from my part. So, but it's I don't mind you argue. I don't mind you arguing it or whatever. But I think the affidavits are enough. Mr. Justin has an issue with that. He can raise it, but at this point, I think it is a legal issue, but it frankly, needs a little bit more research. I have a question about that after, but that's where I'm on that. And as far as, and again, I'm not speaking for the board, but Beth, obviously, I know you did get a letter late today or yesterday, and I think you would, in fairness, if you want to submit something written in response, within the next 7 days to that, that would be helpful too, if you want to do that. So you're not prejudiced in any way by that.
Great, thank you, Mike.
Yeah. Madam Chair, I think Mr. Moore, through his counsel, would like to probably give some testimony.
Fine.
Thank you, Madam Chair. Yeah, I'd like, probably the best way to approach this is just for me to ask a few questions of Mr. Moore as to what exactly happened with respect to these particular violations. So if I may, Mr. Moore, you're the building official of the town of Tiverton?
Yes,
And how long have you held that position?
since June of 2019.
Prior to holding that position in Tiverton, were you employed by other municipalities?
Yep, I did on and off 15 years in the town of Little Compton, Rhode Island as the building and zoning official, and I did almost 4 years as the building and zoning official in the town of Marion, Mass.
Okay. Overall, how many years have you held these positions?
20 years.
Mr. Moore, we're before the board tonight on a cease and desist letter you issued to Highland Ridge Farm LLC on July 23rd, 2020. And for the record, the property is located where?
536 rear is what we have off of Highland Road.
And at the time that you, of the letter of violation, the cease and desist letter, excuse me, how is this location zoned?
R40.
And what uses are permitted in an R40 zone?
Residential and accessory uses.
Okay. What prompted you to make an investigation of this location?
So I got a call from the neighbor where the 40-foot strip of land is. They had been calling for a while as they were getting close to cutting trees to their property. If you don't mind, sir, I'd like to just give a little synopsis. This letter wasn't really written to be appealed. I know it's poorly written. I'm sorry, I'm not a lawyer. But I did cite Town Code 65, 1 through 13, which is our soil and sediment control. There was no soil and sediment control anywhere on the 40-foot strip or at the top of the hill. This is a piece of property that is 60 foot higher than the old Booger Marsh Road. And as Tom was getting, and I've talked to Tom was very gentleman. We talked beforehand. He told me he had 2 million tons of rock that he wanted to get out of that mountain. And he had a legal license to do it. But we had a nice conversation. I didn't put that in my letter because my letter was really to just hold him off on cutting the trees on the 40-foot strip and the 60-foot drop of land without doing the proper soil erosion and having the proper curb cuts in place before you actually do the work. Cutting trees and hauling them out and stumping, if there is any stumping, is considered development in this town. You will have to do soil erosion. That is the reason for the letter. It didn't need to be appealed. It probably could have been worked out, but for some reason they wanted to appeal it instead of working it out. Tom, in his defense and good nature, stopped cutting trees. So when he got to the crest of the hill, that's about 100 feet away from his 40-foot strip, he stopped. That was the day I went out and met him. We spoke. A week later or a few days later, I hurried up and sent this letter with all kinds of mistakes in it. I apologize. I'm not an attorney, but I am tasked with responding to complaints for building and zoning violations in town and town code issues. And Tom, I have one question for Tom. Can I ask him a question, or is that out of bounds?
Out of bounds.
Okay. I am not a botanist, nor I am qualified to say where wetlands are. So I would just say, if you're going to talk about wetlands, you should bring an expert in and have a plan on where your wetlands are on your own property. If you're going to make statements about it, that's what I would say about that. But anyway, there is a violation on the town code about soil erosion. There's no soil erosion out there on the 40-foot strip or anything. Tom told me he wanted to access that. I didn't put it all in the letter. It's too long. I just wanted them to stop till he got his permission from DPW. It's a simple request. Tom did it. Now it's an appeal. Instead of working it out, go get your approvals from DPW, put your soil erosion down and do your developing or whatever it is you have a right to do on your property, but do it properly. That's all. That's a simple request. I don't think it's a big deal. The graveling thing, if we can't talk about it, that's fine. I would love to read my letter, but if it's out of bounds, that's fine too. I'd like to offer it as evidence A, Exhibit A, and I can read you the letter if you'd like. That's all I really have to say.
Which version of the letter are you talking about?
The one that was submitted on, sent to the board on the 30th, and I guess it did have a problem with it, so it was resent today. And I would like to add, the day before the last meeting, we received documents less than 10 hours before that hearing with those affidavits. It just so happened that the meeting got canceled. So you actually did the same thing the last meeting, submitting documents 24 hours before the meeting.
Mr. Martin, we're not going to work. That's okay. We're going to allow her to the
I understand. I'm not a lawyer. I'm just a.
No. Just, I get it. We acknowledge that Ms. Noonan submitted something, and we're going to give extra time for her to respond to our letter, the town's letter. That's not fine. Can I just ask a question? Justin, I'm sorry. I don't mean to interrupt.
Absolutely, of course.
Mr. Moore, again, when you went out to the site after, you were obviously at the site prior to this July 23rd letter that you sent him?
No, Tom came to the town hall.
Okay.
And that's when he presented me with that paper permit, and we talked, and we had a, I don't know, half-hour meeting. It was cordial. It was fine.
Not relating. So when you use the term development activities in your letter, what were you referring to?
Basically, cutting trees and hauling trees with a skidder is disturbing soil, especially when you have a 60-foot rise above houses. We have 2 residential structures within 100 feet of where he was going to be cutting trees, and soil erosion, not counting the roadway below, which is called Old Boogamosh Road, which I have a typo in my last letter also.
So, Mr. Moore, when you refer to Town Code 65(1) through 13 in your letter, that's the soil erosion regulations of the town?
Yes.
And were you concerned that be met, whether he was putting in a road or just cutting trees or whatever? You needed some soil erosion plan?
Especially due to the grade change there, the 60-foot grade change from the top of that crest of that hill. I knew it would adversely affect the neighbors.
And did you have a discussion with Mr. Chase about your concerns prior to this letter?
No, we didn't talk about that. I had gone out the day of the complaint, and Tom met me over there. And the tree cutter was there. Tom stopped cutting. He didn't cut the trees as far as I know. So I appreciate that. It was more about just getting permission to do it before you do it. That's all.
When you say permission to do it, you're talking about having a soil management plan?
Well, and the curb cut, which your soil management plan goes along with your curb cut.
Right.
You know, if you're going to use that 40-foot strip, I mean, Tom told me he wanted to go up there and gravel. That's what he said. I mean, I can only go by what a man says.
I'm sorry, Justin, go ahead.
Not at all. Not at all, Mike. Mr. Moore has expressed his wish to read into the record the letter, but I understand the solicitor has recommended that it be admitted and that Attorney Noonan have a chance to respond in 7 days or whatever the board would decide. And I would leave that to the board as to whether you'd like to hear that read now. It's pretty comprehensive and really outlines and fleshes out and the original complaints that Mr. Moore had. So I would leave that to the chair if the board would like to hear that.
From my position, I would object to that at this point. I think we've got a couple things up in the air between my being allowed to respond to that. You know, Mr. Moore is now saying that this really wasn't something to appeal, even though the appeal language was there. So it makes a better context for what's happening. And then this letter now that you've asked to be read, I'm concerned about that without my response because it could be viewed as an expansion of the original notice of violation. So my thought is, if I get the time to respond to that, I know, Mike, you said you might have to do some research for the board on the non-conforming use. Maybe we can do that, put this over to the next meeting, and, Bill, maybe with Tom, we can, now that it's a little clearer what exactly you're looking for, and maybe I got lost in the letters and the other stuff that was in it, kind of seemed more like a shot across the bow. That I've been in, I've had conversations on other issues with, the solicitor and the planner. We met out on the site to look at things. So I'm wondering if maybe this might be a good chance, since there are other things to do on this appeal, do them and then continue this, continue it for next month, do those in the interim, see if we can either get any further resolution before coming back to the board.
I think that makes sense.
I see my client shaking his head affirmatively, so.
Is that affirmatively? I'm looking for my client. Hopefully he
was on the phone.
Okay.
We're all nodding at this point.
Okay. Want a big nod for that thing I just suggested. Okay.
Let me just ask for the benefit, and I do want to do research on this, on the gravel part of it. And let's assume for a second that you're right, that the board doesn't have determination to rule on a grandfathered right, and that would have to be the Superior Court. So to the extent that your client or some other client were to begin earth removal activities at the site, is it your position that the 1973 permit is valid?
Well, let's go back. First of all, it's not earth removal. It would be it's the extractive.
I'm sorry, the extract. I used the wrong term. I'm sorry.
Excludes from earth removal. And I think, and I've litigated non-conforming expansion of extractive industries before, and it's not just one thing. I think the permit, the 74 permit helps. I think, stuff from Betty Jerome helps, stuff from other people, it all sort of, I've described it, goes into a hopper, and then the Superior Court would decide whether or not you've got, grandfathered rights on it. So is one piece dispositive? I don't necessarily think that's the case. Do I think it's an important piece? Yeah, I do. So it's cumulative in my view.
So I guess my question is, if your client were to begin this extracting on the towns, and the town would have an issue with it, if we have an issue with it, then I would assume that our remedy would be an injunction until we can litigate that issue, whether or not it's a grandfathered right in Superior Court.
Yeah, either, a DJ action, a declaratory judgment action, or something like that. Yeah.
All right.
Yeah.
I just want to clarify that. Yeah, that might be helpful. But it appears, Madam Chair, it's up to the board, but it appears that maybe a little discussion between Mr. Moore, Ms. Noonan, and would be beneficial, and that would give me time to research the grandfathered issue, and then we can come back, and then maybe it could be resolved prior to that. At least for the development activities. I'm not prepared to make any type of decision yet. The board shouldn't be prepared to make a decision on the gravel operations because it is going to require some research, and it looks like we may have to be in another forum anyway. So
Yeah, I think that makes a lot of sense.
and I will say that Mr. Chase has been compliant with this letter, and we appreciate that as well. So that's good. So.
Well, I think that makes a lot of sense. I'd like to poll the members of the board and see what your feeling is about a continuance to another day. To give our legal counsel an opportunity to do some research and to see if any kind of negotiations between the parties can solve the problem.
Absolutely.
That's fine.
Okay. I mean, is everybody on board with that?
Yes.
Yes.
Okay.
Yes.
Quick question, Justin, do you have a problem if we're working out with Mr. Moore on issues relating to the first part of the violation, if we just deal with him directly, or do you want to be part of those discussions?
No, absolutely not. I'm sure if there's anything he needs to communicate with me. So,
okay.
If he was raising his hand, though, I don't want to talk for him.
I just want to be clear.
I do want him involved, as much as I need him, because
oh yeah, I'm not.
I'm outgunned here.
No, I'm not trying to outgun you. I just try, anyway,
It's
not to
only-
complicate the board, but I'm trying to make it easier, not more difficult,
Okay.
you know, so.
I
We're only
understand.
cutting firewood, Bill. Don't worry about it.
All right, there is someone on Zoom that has their hand up. This is an appeal, so it's a paper appeal. It's not really testimony, but they have been, if the board wants to hear, that's up to you. But it really, this is we're not taking testimony from neighbors or at this point because it's a paper appeal from a decision of the town.
I think that's, we could put it over to the next time if those people are seeking to speak. I hate to shut anybody out, but let's
Okay.
just continue that.
All right, thank you, ma'am. So Ms. Hudson, we'll get back to you at the next hearing. All right, so I think
So would we do a motion or we're just gone?
let's do a
Continue
motion.
To a date certain.
Yeah, let's do it to a date certain, which would be the next meeting, which would be December, I believe. Julie, when's the next meeting?
December 2nd.
December 2nd. November?
Well, we have a special meeting on November 18th if you want to do it then. Otherwise, it would be December 2nd.
Wait.
Let's do December 2nd.
Yeah.
All right. Is that good, Beth?
Yes, that works. That's fine.
Justin, is that good with you?
Yeah, I'll just double check. Yeah, that's fine.
Okay.
Okay, we'll
Okay,
make a
thank you.
motion to continue this discussion to December 2nd.
I second the motion. All those in favor?
Aye.
George?
Aye.
Me, yes. Dave?
Yes.
Jay?
Yes.
Wendy?
Yes.
Okay, unanimous. Thank you very much.
Great, thank you.
Thank you. Thank you, Mr. Chase. Mr. Moore.
Thank you.
Thank you all.
Bye.
Have a good night.
Good night. We have two sets of meeting administrative matters to review. September 2nd and October 7th meeting minutes. Have you all had an opportunity to review them?
I make a motion to approve the minutes.
Second,
Second.
all those in favor? Dave,
Aye.
George,
Yes.
Wendy,
Yes.
Jay,
Yes.
me, yes, unanimous. The next matter, I know Julie wanted to bring up the annual calendar for our meetings. And
Right, so I think everybody has a draft of the calendar. And so one of the things, I think it was Wendy that pointed out to me, was that appeals were supposed to be heard within 30 days pursuant to the ordinance. And Lisa and Mike, I sent you the language from the ordinance today, referencing both section 4 and then section 6, where it says that appeal, special use permit, or variance should be heard within a reasonable time. And so I didn't know whether that gave us the latitude that the appeal could be beyond the 30 days. Or did we need to stay within that? Because it would impact really the extra week that we have tried to maintain for the advertising and doing it 3 weeks in advance instead of 2. Mike's taking his tie off. He's
I'm
exhausted.
sorry, I just realized I have the camera on, but I have to take my time off. Sorry about that.
You gotta be careful with the camera on.
I know, I forgot.
No
So
fast moves, Mike.
Stuff in the news, you know.
Yeah, I know. You're making me blush now. You're right.
I'm deferring to you, Mike.
You know what? I didn't really look. I know you did send that to me. I didn't look at it because I actually came in late today, so I did not look at it. But I mean, I think the 30 days in a reasonable it adds an extra week, basically. Is that what it did?
Right. So basically, if it's just a little bit more. For instance, the first month, we're saying the closing date is December 4th of this year, and the meeting is on January 6th. They're typically the first Wednesday of the month, unless it's a holiday.
Mm-hmm.
So I tried to give us just over 30 days, so that gives me time to review the application for completeness, go back to the applicant rather than just kicking them to the curb, see if we can get it together.
But that's for an appeal,
before
right?
the
But that's for an
advertising.
appeal, though. We're not getting many of those. That's only when there's an appeal involved, right? So,
Right.
and we don't get many of those. What I would do is I'd leave it as is, and then we just let the applicant know that it'll be a certain date, and we can, if it becomes an issue, we can ask them to waive the 30-day requirement because it's only adding a week. So
Okay. Okay. So I guess the question then is everybody okay with the calendar that I circulated?
Yep.
If you don't recall it, I can resend it to you.
I will say please resend it if you don't mind.
Okay, sure.
Thank
And
you.
Julie, can the stenographers request a copy of that? Is that anything to do with us? Do we need to be there for these
Yeah.
meetings?
Yeah.
Could you send us a copy of that too, so we can put it on our calendar?
Okay. Yeah, I
Thank
mean,
you.
so far it hasn't been approved yet, but I will send it out, and as long as everybody is in agreement, I will post it with the Secretary of State.
Yeah, we have until the first of the year to do that. I know that we want to
Right.
get it done for the January application, but why don't we take a look at it? Everyone can take a deeper look at it. We can get back on the 18th. And
Okay,
that should give us
fine.
enough time, right? That's good.
Yeah, it'd be good to put it on the 18th for a vote and get it over with.
Yeah, exactly.
It'll give her time to deal with it and
Right, well, and because it came up because somebody called me about an application for the January hearing, and so I told them I had only tentative date information at this point to provide, but said that if they wanted to submit something, they should plan to have it in by the end of December, the beginning of December, excuse me.
That's fine.
Okay.
Okay.
And the other things we had, Mike and Julie and I have gotten together to try to think of changes that we could make that would benefit the town, such as advertising in the Secana Times, for our legal notices, and changing the notice mail requirement from registered to regular mail to try to save the town some money. I think a lot of this has to be put before the council, but isn't that correct? We need to see if the board is all in agreement on those matters.
Yeah, I mean, to the extent that our ordinances say it has to be registered mail, we'd have to ask the council to change it. But the state law does allow us to do first class, so that's what we still have to do. We'd have to change the zoning ordinance within our town, but it's really, we're just trying to get a feel from the board whether they think it's appropriate.
so can I, as on that note, can I say, is in this day and age, when they put an application in, can we, like, is an email, isn't it legal? I mean, it's illegal.
No, not for notice, not for notice purposes.
Really? They could say they didn't get that thing. Well, I guess whatever.
Right, and right now it costs us $6.90. I say us, it's the applicant that pays, but for instance, I just did the abutter notices for the petition that we're going to hear on November 18th, and they spent $2,000 on certified mail.
Wow.
I feel like it should be able to go in the Secana Times. I mean, we do probate notices in the Secana Times, and we do title.
Well, that's two different things. That's the legal notice. I'm talking about the abutter notices.
Okay, so can I, Mike, isn't that problematic if we send it just a regular letter and then someone said, well, I didn't receive it? Can they appeal our decision or that whole meeting? I think I know we're asking, trying to save money, but we could turn on us a lot worse than just trying to save $2,000 or save $6, let's say. All it takes is one neighbor to say, I never get it. I wasn't there. I never went out in the rain.
Mike, have you seen this done in other towns? Use the newspaper?
Yeah, there's other towns have gone to the first class. There's a way that the post office can track it's not really track, but you certify that they certify that it was mailed, but it's not certified mail. There's a special form that they fill out saying that it's not approved, but verify that it was mailed on. But again, the law, Wendy can help me out on this. The law says if you put a piece of mail in the mail box and a stamp is on it, it's presumed to have got it first class.
Correct.
And the burden is on someone to show that they didn't get it. It's not on us.
We have found it essential in the past to have
Like a record.
a picture of the person who received the mail, just so that we can argue that they did in fact get the message.
I am actually
Dave, I
totally
can tell you that
uncomfortable with that.
Sorry, since the pandemic started, the post office actually told us they're not even getting signatures. So I don't actually even really have a record of people, the old days of having everybody sign. The post office has not even been getting signatures.
I know, but this is totally just temporary. I mean, well, unless we're going to be this for the rest of it. I'm uncomfortable not having people know that when they get their notice. I'm sorry. I'm uncomfortable with that, but I'm only one in many.
Is it the post office's position that they will never, ever in the future collect signatures? Or is
No, I didn't say that. I just said that when I did the first mailing for 994 and 1000 Main, the gentleman from the post office told us that what a wasted expense it was because they were not even getting signatures because of the pandemic. I'm not saying that that's the way it's going to be always into the future. I'm just saying that, you know, we resumed our zoning meetings earlier this year. I send out the abutter notices by certified mail. I don't get anything back. The only way I have of knowing that it was in theory delivered is that it's not returned.
Which is okay, so, but if we send it first class, we have no idea at all that they got it or not, or like a regular mail. At least we'll send it certified and comes back to you. We know they didn't get it.
But you can send something regular mail and it gets returned to George. Right? If no, it's the wrong address or.
I don't know. I'm uncomfortable with that, but we'll just, whatever.
Yeah.
So I feel like every abutter, the same thing we went through this whole doing a in-person meeting last month, whatever. Every abutter should have the right to be there, speak up their mind, and be 100% notified. You know, I know this is a right. Some people think they're right of land.
I mean, again, the cost is not borne by the town; it's borne by the applicant. But that's fine. If you want to keep it that way, that's fine.
I honestly, I just don't see unless somebody else could argue different. Everybody has the right to know that there's a hearing and should be able to sign and come forward. I'm sorry. It's part of the expenses when you're trying to apply for something. Simple as that.
I'll look into, there are other alternatives in the statute. There's a way to track something that's a little cheaper that's not certified. But
Okay.
the
As
statute
long as
gives
something.
Yeah, the statute gives us some kind of options. I forget what they call it, but it's a special form that the U.S. Postal Service uses.
Good.
We can look into
Excellent.
that.
Okay, good.
Okay. Any other business?
Well, what about the Secana Times? Are you comfortable using that as an alternate for advertisement for the legal notice?
I am.
Can we put it on a town website?
Yeah.
No, it's gotta be advertised, but you can
Right,
also, a minimum, it's gotta be advertised, a minimum. Yeah.
Okay, well, I will say this, I don't know how many people read it. I'm not trying to slight this kind of time, but I don't know how many people get it. But I will say that, but also if we get allowed to put it on our site or somewhere, it would be in a couple places, that's fine.
Well, they also are getting it. I'm required to post it on open meetings on the Secretary of State's website. We post the agenda at the town hall. It's posted at the senior center and it's posted at the library every
Then
month.
it's the kind of time it is. That's fine. Yes.
How does everybody else feel?
I'm fine with that.
Sounds good.
Yeah. Okay. Any new business? Anybody?
No.
Well, I have some comments for Mr. Bishop. And I have to say that you've missed more meetings than anyone else has missed. You don't pick up your packages to read
Wait,
the
is he still
matters
listening?
for the board, huh?
Is he listening?
I have no idea if he's listening. But I'm listening and you're listening.
I'm listening.
And I think
I'm listening.
I think you have never come to me with any suggestion about how we could make the board better. You have never offered any concerns about how this board operates. And you just turned around and gave us a hatchet job on the internet, criticizing me and every member of this board.
Not every member.
You know what you're doing. You have no idea how this board works.
I'm
And
glad the meetings are being
no
recorded.
question that you got on this board to advance your own political career. But if you can't get along with other people and discuss things as a collaborative group, your political future is going nowhere.
Maybe.
I have asked the town council to remove you from the board, not only for your non-attendance, but because of your disrespect of your fellow board members, and your actions discourage other people from volunteering for any town service.
I know. Is this
Good.
the forum, Lucy? Is this the forum to discuss this? I'm happy.
Absolutely.
The
No,
internet.
well, hold on. Let's hold on. Let's I'll give you a chance to respond to Mr. Bishop, but we're not going to let this get to be a free for all because this really wasn't even on the agenda. So let's be very.
No, and I'm being berated.
New business.
I
On
know,
the
I know,
town
but
hall.
it's not specific, Lisa. It's going to be more specific than that. Go ahead, Mr. Bishop, and then we're not going to keep this. We're not going to go back and forth. But I'll give you an opportunity to respond, and let's keep it short, please.
I have freedom of speech, as you do, Lisi, in supporting the recall. And I can write letters to the editor about my experiences. It's not against the rules. I do attend meetings. I do miss meetings. We all miss meetings. Maybe I miss more than others. But I'm
No,
also
we don't
a
all miss meetings. I'm
alternate.
sorry.
Hold on one
No,
second.
no. I'm
Hold
not gonna
on
hold
one
on.
second,
No,
sir.
I'm
I'm talking.
No.
I'm talking. You're going to let me talk.
I'm
Because I'm
glad
going to
you're
talk
talking-
over you. You are
glad
going
you're
to
talking
let
for
me
the
talk,
first
sir.
time.
Because
I'm
I
glad
will.
you're talking for
The
the
first
first
day,
time.
the first day I was on the zoning board, you asked me if I was going to physically assault you, George.
What?
So you can keep your
Okay,
mouth
Lisa,
shut while
Lisa,
I'm talking
Lisa.
because I have the floor.
Listen,
don't know what you're talking about.
this is going nowhere fast. This is going nowhere fast.
I agree with that, Mike.
Thank you. Let's adjourn this meeting and we'll take this up at a more appropriate time and a more appropriate form.
I appreciate that, Mike. Thank you.
All right, motion to adjourn, Madam Chair.
I wish you let me talk. Motion to adjourn. I make a motion to adjourn.
Thank you.
All those in favor? Do we need a roll call for this?
You do.
Who wants to adjourn?
Me. George.
George. Jay.
Yes.
David. David?
He said it was a thumbs up.
Okay. Wendy?